পুরো লোক তো
One, Mr. Chitupriya Ghosh is for the applicant, my lord. Due to personal difficulty, has not yet come to court. I'm praying for not today, my lord. Last occasion, my lord.
Application
My last
applicant মানে
to be added as a party.
yes, my lord. Last occasion, Mr. Ghosh was here, my lord.
সৌনক ভট্টাচার্য
Praying for not today.
my lord should not take up this matter tomorrow my sister is admitted
Tomorrow, I don't think this bench will.
to hospital my sister is admitted in hospital my lord.
Let there be someone to move it if this bench is available. I don't think so.
My lord, I am for the appellant. I am make to say that the appellant's lawyer is absent for the for whole week. So please fix.
She is praying for not today.
No, not this week.
Let us see.
Item 2. Item 2.
No, wait. I am waiting for
Yes. Item yes. Item yes.
Item 4. I am also appellant, my lord. Respondent number.
Mr. is appealing what it was supposed to make his
That after 10th of February,
yes, he submitted that he has some difficulty to
having what to be said, nothing to be said. But on the next date, it will be taken up, Learned Council.
we have nothing to say.
You are representing the municipality.
We have nothing to say. It is his turn and he is making his submission.
Item number 4, not today.
Item 5.
My lord, I am for the appellant. My lord, on Friday, the learned lawyer for the respondent was going on with his submission. Let them conclude it. Your lordship opined that we should file a written notes of argument. And after conclusion of their argument, we shall take only 7 days to file written notes of argument. 7 days will be needed. I was led by Mr. Mojumdar.
After completion of submission.
Yes, all the points to be noted.
Item number. Item number 3. ठीक है, ठीक है, ठीक है, काट दे, ठीक है। Where is your adversary?
Why asking for advisory here? My junior is not advisory here. My junior is not here.
No, I have seen that, in spite of seeing that, I have not expressed that because that will place yourself in some.
But I don't follow now what the system is there. I could have visualizing if that happened in my junior days. What will be the result? Literally kick. Literally kick. Eviction of a trespasser. Nomenclature in the plaintiff is eviction of trespasser. And the plaintiff is claiming his right to, or can I take this note only? Ananda Mohan. This much you lordship can take note. Plaintiff, namely Mr. Abdul Alim, is claiming his right through Ananda Mohan. This is my key point before my. May not be satisfied with this submission. Kindly take trouble to payment to this. Kindly come to page 105. This is the sale deed of 1st January 2005 between Ananda Mohan. Got it?
7th January.
7th January. Between Ananda Mohan and my lord, kindly turn over the page. You lords will get it. The second page. Abdul Alim.
Abdul Alim.
Abdul Alim.
Purchaser.
Abdul Alim is the plaintiff in this suit. So he is claiming the ownership of this property through this deed through Ananda Mohan. And I want to also show to lordship, my lord, the 123, if your lordship kindly come, the schedule of the property. আমার দুর্দশ রকম
123.
123, the schedule of the property.
1 minute.
All that piece and parcel to land of 5/2 rifle range. 123. Internal page 10 of the conveyance. Can you see? Schedule 5/2 rifle range.
Rifle.
Can you mark that
Yes.
and leave it? Nothing more is required. By showing this, I want to show to your lordship the suit property is 5/2 is rifle range, and plaintiff is claiming his right through Ananda Mohan. These two things I want to canvas you showing this document. Now, my lord, kindly is a plain to my lord.
1, 2, 3.
আমার থেকে ভালো
Yes, plaint is in the paper book.
now see
82 to 893. 82. Acha, acha.
same is in the paper book.
Yes,
I don't think so.
it is mentioned there. Plaint of title
What is
suit
the
number
number?
8 of 2005.
This is the arising out of title suit number 20 of 2017.
But the page number which is mentioned there, 82 to 93.
Yes.
On reaching page number 82, it transpires
Plaint
that
of
It is written statement on behalf of the defendant number 1 and 2 in title suit number 8 of 2005.
8 is not our
8
case.
is not.
No. This has to be looked into, but the appeal arising out of title suit number 20 of 2017. And my lord, in the strict rules of compliance, the complaint has not to be annexed to the paper book second appeal.
Not to be annexed, but for the sake of
Convenience.
convenience,
And this
while
is more
prepa-
inconvenient to my lord now.
um, while preparing the judgment, generally we go through the paper book, generally. But in spite of going through the paper book, we go through the
Normally,
original plain
our
written statement.
teaching was, my lord is where our plain written statement to keep in hand and the evidence.
Hmm.
The court is to see from the nothi, is called in Bengali nothi, and who is to show it from our copy. This was the copy book second appeal.
That is the skeleton. What you say, vertebra.
Yes.
There
So
are-
now, my lord, system is changed.
is the
My lord will not get 20.
1 minute.
in the
No,
paper.
এটা না।
That is in the
I-
record. Your lordship will get
Sir-
the else. And otherwise, I will hand over my copy.
Title suit 20 of
20 of
2017.
2017.
Yes, yes,
This is the suit out of which this appeal arises.
yes, yes, yes.
Can you make a note of that? Well, kindly, in this case, I have to show to your lordship the cause title also. Plaintiff is Sheikh Abdul Alim. Not ready, not ready.
No, not that is not the one. Absence of the appellant.
He also briefed me, I am sending. Hey. Phone करते?
Otherwise,
Yes, I know.
Mr. Basu, kindly be
I have
seated.
no problem.
Kindly
I
be
have no
seated.
problem. But sometime I kept myself free for this second appeal.
Kindly be seated.
No problem, my lord. In this matter, my lord, to see only 4 planes. That's why this jumped in.
That's why the proposition of res judicata has come into play.
The only point. Boss, take it there. पीछे yes. ছিল ভগবত যেটাতে সাইড 5 নাম বলতে পারলো না বলতে হাওড়া আছে
No,
বেলি কি হলো হচ্ছে মানে কি হলো বল মহিলা বসে আছে এক বলছেন কি ব্যাপার একটু মানে not responding the call. Ringing.
might be engaged in another court.
It is known to him.
It was known to him. ডিসপ্লে হচ্ছে তো ডিসপ্লে ঠিক আছে What to be done, Mr. Vasu?
make myself free for this because it's continuing part. This is normal course. But it's continuing for overnight part. You have to give precedent on that. I'll take only 10-15 minutes, not more than that at all.
Thereafter, they will say that in our absence.
If you don't come, what can be done? It's known to you. Let me conclude. If they say that, I will repeat. So kindly take trouble to see the plaint. And I am requesting my land.
I have.
No. Okay. He says, okay. You ring him again. ফোন কর হ্যাঁ ঠিক আছে just a copy. So kindly see the plaintiff is Abdul Alim. And who is the respondent? Tarok Das. Kindly take this name also because I will show a plaint where Tarok Das is the plaintiff. Tarok Das, Kumar Satyajit, such and such. Kindly come turn over the page and see paragraph 2.
Yes.
That the plaintiff became the owner by purchase of the ancestral property and his possession of the ancestral property. Kindly pause here for it. Now kindly recall that document I have shown to your lordship at page 105.
7th of January 2005.
He became the owner. This is his case he made out. Now my lord, kindly come to the bottom. Paragraph 5. That Sonarani Dasi, along with others, filed a suit for declaration, partition and permanent injunction before the landed second civil judge, Alipur. Rest, my lord, your lordship need not be bothered. I am not bothering your lordship. And it is plain and simple. Pass a decree of eviction of the defendant on the ground of trespasser to the scheduled property. My lord is well aware, my lord, starting from 1960, the Supreme Court has said, my lord, also reiterated that possession of a property is how many kinds? Owner, lessee, tenant, license. Apart from that, there is no other thing. Another is left out, trespasser. So, my lord, if a person want to evict a person from a suit from a property, he must have 3 categories of right. One is the owner, or he is a superior lessor, or he is the superior tenant. Trying to evict the subtenants, I will evict the subtenants. Apart from that, if I am wrong, kindly correct me. There are no other category by which a person can evict a person in possession. He has to be right to dispossess somebody. Am I clear to my? Now, my lord, kindly see what happened in this case. We plaintiff. Taroker plaintiff.
97 years.
Suit number 24 of 1997. This, my lord, will get probably in the paper book. Also,
Paper book 32 to 37. 32 onwards.
my lord, now kindly come to page 32 of your lordship paper book. Kindly note that date of or number of the suit of 24 of 1997. And this suit of 2017. Who has filed this suit? Tarok Das, the defendant hearing. Am I clear to you? This is the, my lord, this I have to put to your lordship meticulously because this on this entire suit is depends. Tarok Das is filing a suit. Who is the defendant here?
In title suit 24 of 1990.
My lord. Now kindly see the verses. Sri Devasi is not necessary. 2. Ananda Mohan is the vendor of so-called vendor of Abdul Alim. The Tarok Das filed a suit. What is the suit for? Suit for permanent injunction valued at rupees 100. Now, my lord, I will 2 or 3 my lord, paragraphs I will place before my lord in this. That one Jogmaya Dasi and Fulbasia were the owners of secrets of land 5/2 rifle range. My lord, seen that the number also I have shown to you. Kindly come to paragraph 5. The Fulbasia Dasi died leaving behind her only daughter, Uma Das, who subsequently died leaving her only son, Ananda Mohan. Am I clear to mind?
Yes.
Paragraph 5. Anandamohan was son of Fulbasia, who was the joint owner. Then my lord, kindly come to paragraph 11. According to me, this is the most crucial point. That upon acts of the defendant number 1, a cloud has cast upon for removal of the same, the plaintiffs have been forced to seek the relief from the learned court. So there is a cloud on title. On this cloud of title, plaintiff means the defendant hearing the Prarok Das filed a suit against Anandamohan also. He was a party in that proceeding. What was that? Just a minute. Another problem. Mr. Ghoshal is here, but the junior has not instructed him to be here. So he asked me, at my personal capacity, I said, call him. Then, my lord, kindly come to page 36. Relief for a decree of permanent injunction, restraining the defendant one from making forcible
Basu,
possession of the suit.
Mr. Basu, can we wait for
Yes,
Mr.
yes.
Ghoshal?
Yes. Please, nowadays.
Elder than you.
Certainly, much more. Often said. But now, my lord, he is afraid of me because
I'm always afraid of you.
no. Now more because a cause of action has arose, but he is not doing anything to
Respond to that.
respond to the cause of action.
বছর আগে বলেছো ভুলে গেছি তো।
Just say মনে আছে। My lord, for
First of all, let me clarify. After completion of verbal submission, has the written notes of argument been furnished?
No, not written.
Is required to be furnished?
I shall do that and I shall.
No, because
No, I shall.
Mr. Ghoshal,
No.
many months ago,
About 1 year back, 10 months at least. Because minor is sitting in other benches.
I have no problem.
I said, why I have to give reply and give a short compilation.
yes.
So, my lord, on the basis of that pleadings, Tarok filed a suit with this prayer. Prayer, page 36, for a decree of permanent injunction, restraining the defendant number 1 from making forcible possession of the suit property and from disturbing the peaceful possession of the plaintiff in the suit property. I don't know.
Yunus.
This is a suit filed where Anandamohan was a party. In this suit, my lord, a decree has been passed. Your lords will get at that page 38. Is my lord at 38?
38. Written in Bengali.
Yes. My lord has been directed a long back to on vernacular. The court bureau direction was given. Without appreciating that it's more difficult for this Bengalis to read the Bengali language. নথিটি আদেশের জন্য গ্রহণ করা হইল অত্র মামলাটি চিরস্থায়ী নিষেধাজ্ঞা বাবদ করা হইয়াছে নট নেসেসারি নালিশি সম্পত্তি যোগমায়া দাসী ও ফুলবেশী দাসী যৌথ সম্পত্তি ছিল যোগমায়া দাসী হিন্দু উত্তরাধিকার আইন প্রযোজনের পরে তাহার একমাত্র পুত্র সাগরকে রাখিয়া পরলোক গমন করেন সাগর তার পুত্র কন্যা ও স্ত্রী যথাক্রমে মেঘনাথ বিষ্ণু দাস ও সোনারানীকে রাখিয়া পরলোক গমন করেন বর্তমানে মেঘনাথ মৃত তিনি অত্র মামলার বাদীগণ যথাক্রমে স্ত্রী পুত্র কন্যাকে রাখিয়া পরলোক গমন করিয়াছেন ফুলবাসিয়া তার একমাত্র কন্যা রুমাকে রাখিয়া পরলোক গমন করেন রুমা তার একমাত্র পুত্র আনন্দকে রাখিয়া পরলোক গমন করেন আনন্দ অত্র মামলা 2 নম্বর বিবাদী এই মতে বাদী ও 2 নম্বর হইতে 4 নম্বর বিবাদী নালী সম্পত্তি 16 আনা মালিক হইতেছেন মানে খালি পজ করেন So title was under consideration before the court. And what is the title? That jointly, Ananda and other jointly is 100% shareholder of the entire property. Now today consider, rest I will place. If today one of the co-sharer sold the property by Vastu land, so outside, what is the effect? Can Anando without a suit for partition can evict me? I am questioning the question to myself. Answer is no. If Ananda cannot, then how Abdul? How his suit for only for eviction is maintainable. Apart from res judicata, I am coming. Even if lordship see the plain case here, admitted fact, finding of the court that I am the joint owner of the entire suit property. There is no dispute about that up till now. Court finds it, plain case is this. So I repeat, pardon for repeating, Abdul's right is emanating from Ananda Mohan's right. Can Ananda Mohan file a suit for eviction of a co-owner from the suit property without ascertaining his share and extent of his share? Answer would be simple. Answer would be, my lord, no. He first has to ask for a partition. After the partition is effected, if it there also there are so many eventualities comes in. If I am occupying more, then I will pay royalty. This that will come later. But first of all, a partition suit has to be filed to ascertain the extent of their joint ownership. A third party, owner of the property, if at all he has sold out, there is it has been told to me that document is also not genuine. This is not the case yet to be mentioned because there is no challenge up till now thrown. On the basis of the document which is there, court come to a conclusion that Ananda Mohan and plaintiff, my client, are the joint owners of this property. I repeat, joint owners of this property.
That deed in page number
Deed at page 105.
105. Is any map annexed to the deed?
I could have anticipated what my lord is thinking of. Whether the part property was sold out. Can you see this schedule I shown to your lordship? The entire 5x2 rifle range. (123) kindly come.
Yes, 123.
Can you see the schedule? Being premises number 5x2 rifle range. Entire. And 5x2 is the suit property. ছিল তো আমি যখন করছিলাম পুলিশকে বলে দিলাম আমি হ্যাঁ ছিল তো my lord be satisfied. That is, my lord is finding whether it is a demarcated property has been sold out or not. I could have read out a lordship's mind. It is not. Entire 5x2, all that piece and parcel of 2 kata 13 cheaters. No map. And the next 153 butted and bounded like my lord the plain case. 10.
No, my premises number 5x1.
5x2 rifle.
North South 5x3 West Rifle Range Road is premises number 7.
Entire suit property, which is the subject matter of plain schedule, that is the subject matter of this deed. So it is alleged that he has purchased the entire suit property through Ananda Mohan.
Whereas Ananda Mohan
I will not question this before my lord because this is not the challenge of this.
According to you, Ananda Mohan is not the.
He cannot sell even, accepting his right.
Yes.
Now, let us come back to page 39. What is the decision here? 4 নম্বর বিবাদীগণ নালিশ সম্পত্তি 16 আনা মালিক হইতেছেন। কুলবসিয়া উত্তরাধিকারী 2 নম্বর বিবাদী নালিশ সম্পত্তিতে আদৌ থাকেন না। বাদীগণ ও মোকাবিলা বিবাদী 3 হইতে নালিশ সম্পত্তি বাস করেন। এক নম্বর বিবাদী নারী সম্পত্তিতে কোনো সত্ত্ব ও অংশ নাই। তিনি একজন ডেভেলপার কাম কন্ট্রাক্টর। তিনি নালিশি সম্পত্তিতে একটি বহুতল বাড়ি করিবার জন্য বাদীগণকে নালিশ সম্পত্তিতে উৎখাত করিবার চেষ্টা করিতেছেন এবং সেই কারণে উচ্ছেদের জন্য বিভিন্ন প্রকার সমাজ বিরোধী ব্যক্তিগণের দ্বারা বাদীগণের উপর নানা প্রকার হুমকি দিতেছেন। 97 তারিখে তাহার বিবাদীগণ নালিশি সম্পত্তিকে উচ্ছেদ করিবার জন্য সমবেত হয়, কিন্তু প্রতিবেশীদের সাহায্যে তা সম্ভবপর হয় নাই। এই মতে বাদীগণের সত্ত্বে কালিমা প্রতিরোধ করিবার জন্য বাদীগণ অত্র মামলা দাঁড় করিয়া আর্জির প্রার্থনা অনুযায়ী প্রতিকার চাইয়াছেন। 1 নম্বর বিবাদী অত্র মামলা আপত্তি দাখিল করিয়া নিষেধাজ্ঞা দরখাস্তটি প্রতিদ্বন্দ্বিতা করিয়াছিলেন, কিন্তু পরবর্তীকালে তা আর পরিবার করেন না। So my lord, injunction application was contested by defendant number 1, but thereafter expired. Now, বাদীগণ তাহাদের মামলা প্রমাণের জন্য 3 নম্বর বাদী অত্র মামলায় সাক্ষ্য দিয়েছেন। তিনি আর্জির মামলাটি হুবহু তাহার মুখে সাক্ষ্য বর্ণনা করিয়াছেন এবং নালিশি সম্পত্তিতে তাহাদের সত্ত্ব থাকা প্রদানের জন্য ফুলবাসিয়া ও যোগমাদেবীর নাম সিসিএসসির বিল আদালতে দাখিল করিয়াছেন। উক্ত বিলগুলি হইতে দেখা যাইতেছে যে নালিশি সম্পত্তিতে উক্ত দুইজনের সত্ত্ব সীমিত ছিল। সেই কারণে এবং যেহেতু বিবাদী মামলায় প্রতিদ্বন্দ্বিতা করিবার প্রচেষ্টা গ্রহণ করেন নাই, সেই কারণে সমূহ বিচার করিয়া ইয়ে কথা বলা যায় যে বাদীর তাহার প্রার্থিত প্রতিকার না পাইয়ার কোনো যুক্তিসম্মত কারণ নাই। এই মতে বাদী তাহার উক্ত প্রকার মামলা প্রদান করিতে সক্ষম হইয়াছেন। এই মতে বাদীর অত্র মামলাটি একতরফা মতে ডিক্রি করা হইল। নালিশি সম্পত্তিতে বিবাদীর কোনো সত্ত্ব সীমিত না থাকার জন্য তাহাকে চিরস্থায়ী নিষেধাজ্ঞার আদেশ দ্বারা নিষেধ করা গেল যে তিনি নালিশি সম্পত্তিতে বাদীগণের শান্তিপূর্বক দখলে কোনো প্রকার বাধা সৃষ্টি করিবেন না। Court proceeded on the basis that here the title of my client has been adjudicated. Well, there may be, as a Senate counsel, as I must say what is, even if not in my favor, that this is an ex parte order. The judgments of the apex court in this field says if it is ex parte and the issue has not been properly dealt with, then court will be slow to come to a conclusion, yes, no res judicata. For the time being, kindly think that there is no res judicata. But when the plaintiff is filing a proceeding for eviction, I repeat, my lord, Mr. Ghosal was not there, that his right must be better than me. I cannot got an injunction against a true owner. This is settled law. Contrary, when you are filing a proceeding for eviction of a possessor, you must have a better title than the possessor. So far I am concerned, my right has been adjudicated in a proceeding initiated prior to that, where my title has been decided. If that be so, can you evict me on the ground of a trespasser? You could have said that as a co-owner, I am trying to evict you. Separate concept. He is not saying. Nowhere he is saying only that I am the owner by virtue of that deed. That deed said Anandamohan was there. Anandamohan admitted me as co-owner of the property. If Anandamohan is admitting me as a co-owner, then can his subsequent purchaser disown that? Can he test my submission? I'm a trial judge. The first court may not proceeded only on the basis that he has a deed, without considering that that deed has an effect of the entire property. If at all the deed is genuine, I am not questioning deed is genuine because I have not challenged that. Deed is genuine. Can it override a decree of a court? This is the question my lord has to decide, which has been decided by the lower appellate court. My right as a owner has been decided, admitted, not only decided, it is decided, admitted by Anandamohan, because Anandamohan was a party in the proceeding, chooses not to appear. Decided ex parte against me. Also, where the entire chain of title has been, you want to say?
He had contested the injunction hearing.
No, that is defendant number 1. The promoter.
Okay.
Anandamohan was a party only
Only part.
because he was made a party on the ground that the property is not solely belong to me. He was also the co-owner. I admitted that. In that suit, if you lordship say in other way, I have admitted that Anandamohan was also a co-owner because the pleading says so. I cannot go beyond the pleading. If he is the co-owner, either he has to come as a plaintiff or I have to put him as a defendant. Otherwise, suit may be by defect of party. So, I, for the time being, hold that the transfer by Anandamohan to the plaintiff herein is valid. What has been transferred? Transfer is the entire suit property, of which I was declared as an owner by a competent court of law. And without anything more, that my right of ownership has been extinguished by either in a verdict of a court or by otherwise. I have sold out the property, transferred this, that. Can I be evicted as a trespasser? This is the question, my lord, your lordship has to answer. Now, my lord, in the meantime, another thing happened, my lord, that I have filed, after finding this, that my title is going to be clouded. After finding, after this suit is filed, I find my title is going to be clouded. I filed a suit for partition. That suit is, my lord, can you take note of title suit number 8 of 2005 by Tarok, by the defendant, the defendant herein against Anandamohan.
This was
আমার কি রোজগার করা দরকার নেই?
this was filed by 8 of
Tarok,
Tarok.
my client filed a suit for partition against Anandamohan. Just for recapitulation, in my suit of 2024, I said Anandamohan is a co-owner. Paragraph 2. So I want to wriggle out of this problem. I file a suit for partition. That suit has been dismissed. Against that, my lord, appeal has been preferred. Appeal is title number 257 of 2016 is pending.
Title appeal
257 of 2016. ছিল তো,
which is pending.
মানে জাস্ট এ মিনিট, মানে ডক্টর টেকিং নোট বার করলি তো কালকে আলিপুরই হবে। But that, if I don't mention it, but I will be taking my duty. That's why I mentioned it. But I say nothing turns on it, because I cite one judgment for this proposition that if appeal is preferred, the judgment loses its finality. Lying on my lord 55 Calcutta weekly note. This is on his fingertips. This judgment. 16 additional judicial Alipur. 16 additional. That is reported in 1988 volume 2 Calcutta Law Journal 491. ভয় পাই না, কালি ট্রাভেল করতে two paragraphs 13 and 15, relying on 55 weekly notes. But I have a bad habit of marking, my lord. Can you ignore that?
13
And 15.
and 15.
জানি এটা আর তোমার তো ফেল করে গেছে কি হচ্ছে কোথায় ছিলি কোথায় ছিলি তুই আমাকে আগে বল তো পাঁচে মেনশন করে তুই বলে যাবি না কাউকে একটা তোর সঙ্গে বসে আছিস তুই। বেশি একটু লাগবে না হয়ে এসছে কিছু করে গেছো This is already bad. Awesome. Why I am citing this? Mr. Ghosal said, why you are citing this guy? I know you. You will may argue that you are saying that I have a title. So, if the plaintiff does not have a better title, cannot evict me. Now you have unable to prove your title. Your suit has been dismissed. To prevent him from taking this point, I am citing this judgment that is not reached its finality because the appeal is pending. But that only. Now, my lord, now we are at page 40, 41. That injunction was granted, holding, injunction was granted, holding that we are the joint owners. And this judgment was rendered on the next page. Justice HON'BLE.
Referring to
Page
page
41.
41.
Conclusion. Justice HON'BLE rendered this judgment saying that now the lordship can we come to the judgment of the lower.
Judgment of the first appellate court is at
Judgment
page
is Justice Partho Chatterjee now in High Court. Everyone got it?
page number of the
I
paper
have
book.
separate copy, that's why.
Achha.
What about number double?
It's from page 5.
Page 5. Page 5 of the paper.
Achha.
Now kindly
That is
come,
5. Yes.
kindly come to the points for determination. Hello, got it, my lord?
Points for determination.
Second one, whether The learned trial judge correctly held that the defendants having no title are liable to evict from the suit premises property. Defendant means my client. I read one second. Whether the learned trial judge correctly held that the defendants having no title are liable to evict from the suit property. This is the finding of the learned trial judge.
Defendants having
No
no
title.
title are liable
To be evicted
to be evicted from the
from the
suit
suit
property.
yes, I canvass this proposition. If you want to evict a person from this property, from his possession, so you must have a better title than the person who is in possession. So if the person who want to throw away has no title, no right, then you can, if you have better title than him. This only here, my lord, it has to be added in this issue that if you have better title than him. Suppose I am in illegal possession, he is also in illegal possession of the same property. Can he evict me? Answer will be no. Always the person who is having a better title is entitled to evict the person from the property under which capacity, licensee, tenant, trespasser, whatever. He must have a better title. Now, I have shown to your lordship, my lord, the plaint and the order passed in the suit number 24 of 1997. My lord has gone through. Is it appearing from those documents which is part of the evidence in the court below that I have no title? My suit suggests that I have a title along with Anandamohan. So how the learned trial judge, I am asking the question to myself, come to a conclusion that the defendant has no title? After considering the evidence on record, which unequivocally suggests that I have a title. Rather, Anandamohan may have a better joint title like me, from whom you are purchased. What you have purchased? The entire property. I repeat, my lord, can you pardon me for repeating? Can a joint owner file a suit for eviction without having it partitioned? I am taking my case too high that yes, that Abdul, the plaintiff, is my joint owner. Can he file a suit for eviction? According to my humble submission, my lord, he cannot. So, my lord, this is the issue framed by Justice, the trial judge, the lower appellate court. Let us see the decision.
Mr. Vasu, first appellate court.
Yes, first appellate court. Then, my lord, he has to be amended. LCR cannot say. But if follow, initially I could not. The learned trial judge rightly observed that since appeal in the continuation of the suit and an appeal is pending in respect of the judgment of title suit number 17 of 2009, no conclusion can be arrived therefrom. It was finally decided on 24th August 2020. The learned trial judge rightly did not rely on the judgment and decree of the trial suit number 8 of 2005, since appeal is pending against such and such. Not necessary. Can he come down? A cell deed was relied upon. Trial court held that the vendor traced his title, stating that such BB was the owner of a 5x2 rifle range and plot number 2 Jogma Devi and Pulvasia Desi by deed number such and such. And thereafter her death, Anandamohan was the only legal heirs of Jogmaya. The learned trial judge found that the defendant admitted the ownership of Jogmaya Dasi and Pulvasia Dasi, however, denied their inheritance by Anandamohan. Can you pause here for a moment? My lord has read the document which was produced before the court. As it is, my lord, what concurrent finding, Honorable Trial Judge and the Honorable Lower Appellate appreciated the evidence in different way. Your lordship now can see the document. My lord has seen the document. The document itself says that Anandamohan has sold out the entire 5x2. But at the same time, the judgment and decree and the plaint itself, her Anandaman is a party, unequivocally suggests that they are the joint owners of 552. That this finding of the learned trial judge, as rightly held by the lower appellate court, that is incorrect. Then, trial judge found that the defendant admitted the ownership of Jogmaya Dasi and Pulvila Dasi, however, denied their possession. Though they claim ownership by way of inheritance, but failed to establish and assert the chain of inheritance, he found that the DW1, though claimed inheritance from Sagar Das, but failed to say and prove any title deed in this regard. Prove that Dulari was also a daughter of Pulvasi. Then, my lord, kindly turn over the page. Kindly come to first paragraphs, last 5 lines. But recital. It starts with but recital in a deed. But recital in a deed is nothing but the statement of the vendor, which binds him and the successor interest, but not to others. In addition thereto, it may be mentioned that the mere recital in the title deed as to chain of title does not prove the chain itself. If I say in the deed that I am the exclusive owner of entire property, that will not suffice, because here in this case, a judgment and decree on this property categorically suggests that we are the joint owner. Then, kindly turn over. This paragraph I can skip. Kindly turn over. It starts with at this juncture. At this juncture, I found like to lay emphasis on the records of title appeal number 205 of 20.
Internal page 4 of
4.
Mhm.
5.
5.
4, I request you also to see. According to me, nothing turns on this. 5. At this juncture, which starts with at this juncture. At this juncture, I would like to lay emphasis on the records of the title appeal number 205 of 210. That is, my lord, title suit number 17 of 2019.
Where it is at this juncture?
Is another. This appeal was dismissed on 24th August 2020.
Go to which paragraph you are placing?
I
Which
am
paragraph?
page 5, first paragraph, as this juncture. Not telling.
Page 10 of the paper book and internal page
Yes,
5.
I am not waiting for. Sorry. Oh, Milvan. So kindly come to page 8 at this juncture. Second paragraph,
At this juncture, I would like to lay
I am placing from my own, that's why it is may not tally.
internal page 3.
Yes. At this juncture, I would like to lay emphasis on the record of the title appeal number 205 of 2010 between the self-same parties of this appeal being directed against the judgment and decree of title suit number 17 of 2009, 4th Court of Alipur, of a suit for declaration of permanent injunction against the present appellant defendant in respect of the same property. In the suit, the plaintiff and judgment and decree in title suit number 24 of 1997 were admitted in evidence, which I placed before my. It reveals that in title suit number 24 of 1997 of the civil judge, second court, the present defendants appellant instituted a suit against Devashish Ghosh and others, where Anandamohan along with others were implicated as a pro forma ignorance defendant. Pro forma has nothing. The effect of a decree in presence of a pro forma defendant is to be discussed at the subsequent later part of the judgment. But in that suit, while searching out title of the person in the suit property, the learned civil judge held that Pulvasia and Jogmaya were the recorded assessee of the suit property. She further found that the plaintiffs, Tarok, claimed as co-owner of the suit property. Can you mark this person? I am the co-owner. Inherited from Megnath, who is one of the legal heirs of Sagar, the only son of Jogmaya. The learned judge further observed therein that on perusal of the evidence on record as well as the absence of any challenging, there was no reason to reject the prayer of the plaintiff. Though title suit number 24 of 2097 was a suit for injunction, but this was a clear pleading about title of the plaintiff therein. In order to find out the binding force of the judgment about title in a suit for permanent injunction, the order of apex court relied upon my lord I will not multiply. 1994 also relied upon. Now kindly turn over. No, kindly come to after the citations were there. Is it settled law? Kindly got it. It is settled law. It is settled law.
Paragraph starts with.
After 1994 Supreme Court relied upon thereafter.
Acha, acha. It is settled law that.
Settled law that a suit for injunction when title is an issue for the purpose of granting injunction, the issue directly and substantially arises in that suit between the parties. When the same issue is put in issue in a later suit based on title between the same parties or their previous in a subsequent suit, the decree in a injunction suit equally operate as a judicata. Then, my lord, 2000 volume 3 Supreme Court relied upon. Then, my lord, the honorable judge is saying, res judicata on the question of title to the extent that the adjudication of title was essential to the judgment, but under the question of the right of possession was the only issue actually or necessarily involved, the judgment is not collusive on the question of ownership of title. From the copy of the plain title suit number I have shown to your lordship, 24, it is evident that the defendant number 1, 2, 3 claimed title through Sagar Das. The court also held that the plaintiff claimed as co-owner of the suit property, being inherited from Meghnad, and on perusal of the evidence on record as well as the absence of any challenge, there was no reason to reject the prayer of the plaintiff. Thus, the decision of the question of possession is res judicata on the question of title to the extent that the adjudication of title was essential to the judgment of title suit number 24 of 1997. True, the decree of injunction was passed against the defendant number 1, but Anandamohan was one of the defendants to that suit, and that suit was decreed in his presence. Then, my lord, kindly see the two pro forma defendants has been discussed. I have not asked you also to deal upon this question. There is nothing on the civil procedure code which is called pro forma defendant. Then, my lord, it's again in title suit number 24 of 1997. Anandamohan was a party to the suit, and the plaintiff therein, in the present defendant, claimed themselves as co-owner of the suit property, along with defendants Anandamohan. In that suit, a right to relief of property was differently alleged to have existed against Anandamohan. If he denied the interest to deny the title in the suit was brought to our notice. Anandamohan and his successor in interest by or against the present defendant. Such common question of fact arose as to whether the present defendant's respondent had right as co-owner in the suit property or not. More so, in terms of Order 7, Rule 5 of the court, Anandamohan interest as co-owner in the suit property was shown in the plaint of title suit number 24 of 1997, and he was liable to answer if the plaintiff is that suit was that co-owner in the suit property therein. This is the reasoning, my lord, for arriving at a conclusion contrary to the discussion by the honorable trial judge. I am at one with the finding of the London Lower Appellate Court so far as the res judicata is concerned. I am trying to add one thing, that even if it is not res judicata, I am not relinquishing my point. It is res judicata, obviously. Even if not res judicata, once the court found that I have a title in the property, can I be ousted from the suit property without adjudicating that the finding of the earlier proceeding was bad in law? Here is a suit for eviction of a trespasser. So now, the evidence now before my lord is co-owner versus co-owner. I put myself little better case than Mr. Ghosal, that I am saying that this Abdul Alim is a co-owner. I am also a co-owner as per the order of the court. In 1997, court held that I am a co-owner. So, what a co-owner can evict it. Answer. cannot evict. Either on the ground of res judicata or on the ground of that he does not have a better title than me.
Anything more? Only thing
Inquiry from court, but right.
only one thing I want to ask. This court will have to go through the several title suits. Be kind enough to mention the title, the number of the title
Yes,
suits.
yes. Three, my lord.
One is
One,
24
my lord,
of
I have already, my lord, I recorded this appeal arising out of title suit 20 of 2017. My lord, I take note of.
this one is arising out of
20 of 2017.
2017.
And now the res judicata point is emanating from title suit number 24 of 1997.
24 of 1997. Yes.
Filed by just some assistance required. Filed by
Tarok.
Tarok Das, who is the defendant here, plaintiff in that suit. And I have filed one partition suit, that is title suit number 8 of 2005.
Defendant here and plaintiff in that 24 of 1997. Tarok Das. Tarok Das.
Tarok Das is plaintiff in 24 1997.
And the other one,
Other one is, third one is title suit number 8 of 2005.
partition suit,
Partition suit dismissed on 23rd December 2016.
against which appeal has been preferred.
Against which appeal has been preferred. I have given the number also, that is pending. Number 57 of 2016.
Suit for partition dismissed on?
Dismissed on
No,
23rd
not the
February.
date. No, not the date. Dismissed for?
It was dismissed.
Dismissed.
Probably because my title was not there on the ground. I have not checked up, but I must be candid because I have to prove it. এইটা বলেছি। পাল্টে যাবো না।
Yes.
Any more query for my
No.
That's all. And I am relying the judgment which has been relied by the Honorable Lower Appellate Court. That's why I am not multiplying.
And in addition to that, you are relying
The
upon
only judgment to show that
1988
not list is final.
CLG. CLJ 490.
Get to them.
After fortnight
As a minor's position will permit us,
or
along with the compilation.
yes, obviously, both of you. Maybe after a week, if this bench is available.
That's a very crucial point.
That is the difficulty. Because after all, judges are human beings, we are also human beings. My is hearing so many matters every day. So naturally, very difficult to remember each and every point. So
That's why I am seeking for the written notes of argument. Mr. Basu was arguing,
No.
was not one with this court on this aspect as regards to written notes of
probably, I am subject to correction. Lordship probably has taken note when we argued the matter.
Yes, yes.
Yes. That has been taken note.
But it's still very difficult to reconcile at this stage without hearing a phrase.
Nowadays, my lord has not been provided with the red khata. We used to in our younger days find the judges are writing on the date and the date khata is always come. When the date khata is coming to work on that, we find my lord is coming. All systems has gone.
This one also has some red portion.
খুঁজে পাওয়া যাবে না।
Systems are being modernized, so we may expect someday that a video recording could be one of the arguments. So this is so the lordship can hear it again. Yeah, so whatever was the result, I am very glad to come here and suit against Mr. Rasu.
He is so affectionate to me. Not only for the
You are
district.
you are affectionate to me. You are no, I am not affectionate to you.
Thank you for the cooperation.
So tentatively after a week,
Not prior to that.
I should be
Not-
ready.
not-
I should be ready for 1 week,
Yes,
if not otherwise.
within 1 week.
I shall be very brief because my friend has argued only mainly 2 or 3 points. That's the thing. Whatever co-owner can.
Co-owner and better
I
title.
reserve my submission. Only thing I reserve, kindly appreciate one thing. My lord remembers that so far as eviction is concerned, my friend is correct. Better title to be proved. 1975 Calcutta page 200.
I said that is in his fingertips.
Justice R. Bhattacharya's judgment. The suit for eviction.
দুটো আছে কোনটা বলো এর বাবা হ্যাঁ
Oh, the suit was for eviction of a tenant. Tenancy relationship could not be proved. Still, eviction degree was granted. After order sir, rule 7. That is why I said, I know very little of it.
in anywhere it is have to be better.
Better title.
Both illegal possessor, one cannot throw out.
So again I say I reserve my submission.
Certainly.
Whether a co-owner can file a suit, that for that the special provisions are there. Anyhow, about
থাকতে পারে, দুটো তারা
Mention submission. Act refutes the same. Question. Counsel representing Mr. Koshal, senior counsel, representing the appellant, submits that he will be apprising the court as we have to reply on the next day. Yes, sir. Next. One, one, one. Yes, Mr. Counsel.
Yes, please. Matter on the last occasion, I have reading the paragraph 12 below. That the petitioner through her authorized agent and advocate Sri Sudhanshu Shekhar Basu determined the tenants common
Internal page 12.
paragraph
Paragraph 12.
paragraph 12, page 5 of the plaint below.
1 minute.
That the petitioner
No, এটা ফার্স্ট অ্যাপিলেট কোর্ট, ট্রায়াল কোর্ট। Replacing paragraph 12 of the plaint.
Plain below.
Yes.
That the petitioner through her authorized agent and advocate Sri Sudhanshu Shekhar Basu determined the tenants in common in by an ejectment notice under section 6(4) of the WBT Act 1987 dated 25/11/2005 by calling upon the opposite parties to quit, vacate, deliver up vacant and peaceful possession of the tenanted premises known as schedule as at premises which the expiry of the last day of month of December 2005. And the said notice was separately sent in each of the by name by registered post with AD in respect in separate envelope. The notice sent by registered post which was accepted by one brother on 28/11/2005 and the letter containing the notice have returned back undelivered with the postal receipt of not claim and the same tantamount to a valid legal service notice upon the address of each and every notice upon the opposite parties since service of one in service of other parties. My lord, in this paragraph, the defendant, the plaintiff himself admit that service is effected only against the one, not by the others. This is a own admission, my lord. If in the ejectment suit, my lord, notice has to serve to all the defendants. Here only, as per plaintiff's contention, only one defendant has been served. Moreover, my lord, the point I have taken on the earlier occasion that the notice is within a year from the
Within
date
1 year of purchase.
purchase, my lord. So, my lord, on the point of law, this notice is bad. As per section 6, subsection 2 of the West Bengal Premises Tenancy Act, this notice is absolutely bad.
The date of the notice is
Date of notice is, my lord,
25/11,
25/11/2003.
2005.
2005. Yes, my lord, 2005. 2005.
Yes.
And my lord, regarding service, my lord, the remark is not claimed. It is the plaintiff's case also that other defendants are not residing in the said premises, my lord. In the plaint, it has been stated the other defendants not residing in the said premises. So not claimed in this respect is not the good service. If the other defendants are residing in the said premises, thereafter, if they not claim the letter, tantamount to refusal of that notice, that is a good service. But when the plaintiff himself says they are not residing in the suit premises, then not claimed is not a good service.
So according to the landlord, only one was residing in the tenanted portion.
Yes, my lord.
He has been served. He or she has been served. Apart from her or him, nobody else has been served. In respect of the others, it has returned with the endorsement not claimed.
Not claimed.
Not claimed. And it is their admission that these persons are not residing there. So according to you, it does not amount to service, good service.
Good service. Therefore, that the true copy of the ejectment notice dated 25/11/2005 along with Xerox copy of the registration slip and the acknowledgement card showing the service of ejectment notice and then the copies of invoice of the registered letter, envelope of the registered letter with the postal remark not claimed are herewith as part of the plaint and the petitioner undertake to file the original of those documents in the ejectment cases. That in spite of due service of ejectment notice dated 25th 11/2005 as mentioned above, the opposite parties have failed and neglected to quit, vacate, and to make over the vacant peaceful position of the Schedule A premises to the petitioner, but on the contrary, our opposite party are still holding over the position of the A premises, and as such, opposite parties are liable to pay damages at 50 rupees per diem. Additionally, landlady for the wrongful use and occupation of the tenanted premises from the date of degree till recovery of, that is the, now my lord, the ground of ejectment. The grounds of ejectment of the tenant in common are as follows: that the opposite parties are willful defaulter in the matter of payment of rent and arrear of rent on and from the month of November 2000 till now, that out of the said opposite parties, two tenants in common are residing in their own dwelling house, which I have pointed out. They are residing their own dwelling house. So they are not residing in the suit premises. In their own dwelling house elsewhere for more than 3 years, and they are residing in their own house and having kept the rooms under lock and key, and for that the rooms are being damaged by day and also liable for eviction as per law. That the opposite parties are living in the tenancy are quietly conduct which is nuisance and causes annoyance to the neighbors, including the landlady. That the petitioner's landlady and her family is reasonably required Schedule A premises for their herself accommodation and her family members. My lord, in this point, my lord, I have categorically stated that there is no commission work to prove this case.
So according to you, reasonable requirement ought to be proved by commission. It has not taken place.
Not taken place. And my lord, when they purchase these buildings, they knowing fully well the building is fully tenanted. Yes, my lord. And my lord, moreover, my lord, when they purchase, they know the suit premises is fully tenanted. In spite of knowing this fact, they have purchased these premises, and within 1 year from the date of purchase, he served the notice. That the requirements is this, my lord. The one room is required for the landlady and her husband for dwelling purposes. One room is required for the daughter of the landlady, who is a homeopathic medical students for the separate living room and studying purpose, and further one room for her chamber come visiting of patients in the suit property, and one room is further required for the said daughter for strong official apparatures and medicine to treat her patient and to render medical to the patients, preferably in the ground floor, and one room required for school going students, the only son, the landlady, for his studies, and living room aged about 12 years, and one room is required for store cum kitchen of the landlady, and one room is required for Thakur Ghar, being old Hindu wife and husbands. One room is required for drawing cum guest room to visit the relative of the landlady, and B, that one room is absolutely required for the husband of the landlady who has got a big stationery shop, and particularly the said stationery shop room has got no godown to store the costly item, but to keep those articles there and to stay in the shop room at night to protect from the theft of those stationary valuable articles for the livelihood of the petitioners and her family members at this stage. Thus, the petitioner landlady reasonably required the entire Schedule A premises for her own accommodation for his family members having no other alternative accommodation. Now, my lord, in the cost title of the plaint, it is found that there is a other premises of the plaintiff. In the cost title of the plaint, the address of the plaintiff is 52 Gorpar Road, PS Narkeldanga, Kolkata 9. This is their places. And my lord, defendants is 11C Rajendra Lal Street. In the cost title, my lord, first.
13C.
My lord, in the cost title, my lord, this is 52 Gorpar Road.
Schedule of the property.
Schedule of the defendant's property. Tenanted property. Scheduled property means the tenanted property.
Tenanted property.
That is our property, no doubt, our tenanted property.
That is
But
13C.
but the plaintiff residing at 52 Gorpar Road.
Yes. Plaintiff is residing at 52 Gorpar Road, PS Narkeldanga.
Nanga.
The suit property is 13C Rajendra Lal Street.
More or less in the same vicinity, my lord. So, my lord, commission work is necessity for that reason, that whether the plaintiff has got sufficient accommodation in their own building or not. Because it is the plaintiff's baby to feed on. Plaintiff is to prove by sufficient proof and by conducting commission work whether he has actually got any reasonable requirement or not, or the requirement is desirable or not. The requirement may be desirable, that cannot pass by the learned court. But where the requirement is actually reasonable, then the honorable court pass the decree. But to prove that, a commission work is necessary. Because permutation, combination, whether this room is there, that room is used for that.
Clear picture is to be placed before the court, for which commission is required to be.
Absolutely, my lord. Absolutely. And their report has to be exhibited. Nothing has been done. Commission work is done, so report has not been executed. Now, my lord, thereafter, paragraph 17, the cause of action of the ejectment case arose on and from 1st day of January 2006 within the tenant, when the tenant incomes have willfully failed and neglected to quit vacate the suit premises as per requisition of the ejectment notice at premise number 13C Rajendra Lal Street, PS Narkeldanga, Kolkata 6, and which is within the jurisdiction of additional rent control. So, my lord, kindly, therefore, what my contention is this: notice is not good as per law, section 6 subsection 2 hits the notice. Notice is not served of all the defendants, because save except one defendant, there are other defendants residing in elsewhere. It is the admission of the plaintiff. So, notice is absolutely bad in respect of legality and also the validity, and also in respect of service of the notice against other defendants. Now, may I place the written statement below? Lord, it is your hand, my lord, written statement.
Yes, written statement.
In the written statement, I have categorically denied the contention made in the plaint. That is, my lord, paragraph 1, that the plaintiff has no cause of action for the suit against this defendant, that the suit is not maintainable at law and in its present form, that the suit is a chance suit, and at the same time it is speculative, harassing and malicious one, that the suit is barred by principle of estoppel, waiver, acquiescence, that the suit is bad for misjoinder and non-joinder of necessary parties. The date is Sri Sri Nikunjo Bihari Jiu Thakur, the inducting landlord of the predecessors of the defendants, as also the owner of the property, is necessary party to the suit. That save and accept is specifically admitted by these defendants. These defendants deny all other allegations in the plaint, and the plaintiff to the to strict proof thereof. My lord, these paragraphs is a common paragraph, general denial. Defendant, when the learned advocate or the respondent argued that this general denial is not a specific denial. Now, my lord, my contention is this. This is type of general denial, obviously, and denied the contention of the plaint. I never admitted anything. Which point plaintiff has to prove? The plaintiffs are to prove as per their own evidence. If I suppose he have not denied anything, but that does not mean I have admitted his case.
Whether it be specific or evasive, it is denial.
It is denied.
There is no admission.
There is no
It
admission.
is the plaintiff to prove his case.
Absolutely. And my lord, your lordship knows very well, to prove admission, there should be admission should be unequivocal and unconditional and unparalleled. Three ingredients: unequivocal, unconditional, unparalleled. So therefore, mere general denial that does not equip the plaintiff to prove his own case, that I have generally denied, not specifically denied. That's separate issue, denial. But his case he has to prove. In the case of reasonable requirement, he has to prove by commission. He has not. That the description of tenancy as paragraph 7, that the description of tenancy as mentioned in the schedule of the plaint at the suit is bad for particulars determination of the tenancy, since the entire premises number 13C Rajendralal Estate was let out to the predecessor of this defendant, late Anand Dasgupta, by the Sebayat of the DT Sri Sri Nikunjo Bihari Jiu Thakur. That the statements mentioned in paragraph 1 of the plaint are all matter of record, that the facts detailed in paragraph 2 of the plaint is ambiguous and meaningless, and it stands naturally. These defendants are set in a position to controvert the same, accepting the facts that the premises is an old dilapidated one which is still remains as it was. That the statements made in paragraph 3 of the plaint are all matter of records, and the plaintiff is bound to prove her derivative title by prediction of the deed of, by producing the deed of conveyance, as also the permission of the learned district judge, which was not given inspection to this defendant in spite of repeated demands and request. My lord, on the earlier occasion, my learned friend pointed out that I have admitted this deed, but I never admitted this deed. I have directed to produce deed as well as that permission, the decree of the Alipur court, my lord. But that has not been produced on the list of documents or at the time of evidence, that has not been made exhibited. It is an admitted case, my lord. And in absence of that document, this deed is entirely null and void. The derivative title, rather say, the derivative title is through that deed, which is not permissible in the law, is absolutely null and void. Now, paragraph 11, that the allegations contained in paragraph 4 of the plaint speaks for itself, that the plaintiff intentionally suppressed the deed numbers and the place of registration which interfered the registration was this is eligible one, the date of presentation of the plan completed. No? Yes. Plain. The plain, yes. Even if it will be taken that deed of conveyance was registered on 14th March 2005, the plaintiff cannot allege this defendant is a defaulter in payment of rent from November 2000 in absence of any assignment of arrears of rent. However, following the erroneous order passed by the learned court in cause of disposal of the petitioners under section 7(2), this defendant have deposited the entire arrears in court. Paragraph 12, that the allegations contained in paragraph 5 of the plaint are all false, concocted and motivated. It is denied that the plaintiff ever got possession, other physical construction of the premises or any portion there, since these defendants are all through physical possession of the entire premises number 13 by C, Rajendra Lal Street. Never they admitted the plaintiff as the landlady following the so-called derivative title she acquired by virtue of so-called erroneous deed of conveyance. That the allegations contained in paragraph 6 of the plaint are false and specifically denied by these defendants in the earlier paragraphs. That the allegations contained in paragraph 7 of the plaint are all false, denied by the defendants. The tenancy of the predecessor of the defendant started from the breaking period of the month. They cannot said to be tenant from the first day of last day of each month. Milord, if the notice, if the tenancy started from the day one, from the first day of month, then clear month is entire the month. But if the tenancy started from the mid, then notice is to be served to that effect. From 15th, another 15 is one clear month. But here the defendant said that the tenancy of the predecessor of the defendant started from the breaking period of the month. They cannot be said to be tenant from the first day to last day of each month. So eviction notice. So my lord, eviction notice should be in accordance to the rent bill, to the induction of the tenancy. If the tenant is inducted in the mid of the month, then eviction notice should be considering the mid of the month in the next mid of the month.
You are paying rent
But rent is
month by month.
month by month,
English calendar month.
English calendar. But the date of induction, if in the mid of the month, the notice is to be served considering that period. Paragraph 15, that all the allegations made in paragraph 8 of the plaint are production of a futile brain and well cooked up by the plaintiff for the purpose of the suit. It is fact, two brothers have left the premises for paucity of accommodation, but none of them has acquired his own house and kept their room padlocked as wrongly alleged. It is true, no current rent has been paid to the plaintiff since he was neither accepted as owner nor the landlady by this defendant, but these defendants are or not aware were defaulter in payment of rent since November 2000, which was deposited in the office of the rent controller after refusal by postal tender their actual landlord. That the imaginary house as mentioned in paragraph 9 and 10, the plaint does not belong to these defendants as wrongly alleged. The allegations made in para 11 has already been specifically denied. The rest of the allegations made in paragraph 11 to be proved by the plaintiff, but these defendants have definitely information that the premises where the plaintiff resides is her own use and she has further building in the city of Calcutta in else vicinity. My lord, I have categorically stated that plaintiff has got other building that I have shown from the cost title, and defendant also said they have got any other building. So plaintiff has to prove their own case through commission. It has not been done. And I have categorically said they have got other buildings also. So when I have stated this, that statement does not admit his reasonable requirement. This statement does not admit his reasonable requirement. Never. That all the allegations made in the paragraph 12 to 14 are all false claims denied by these defendants. The allegations notice to quit is illegal, inoperative, bad in law, and insufficient to determine the tenancy of the defendant. The said notice was never tendered to serve upon this defendant. Thus, the question of payment of means profit cannot arise at all. The arising suit is liable to be dismissed. My lord, there is one typographical mistake in the written statement, as I have been instructed by my client, that instead of 14, this should be the 18, my lord. Paragraph 17, that all the allegations made in paragraph 12 to 14, instead of 14, it would be instead of, my lord, 18. That I have been instructed by my client that this is a typographical mistake. That is 12 to 14. It should be 12 to 18. This is a typographical mistake. Therefore, 12 to 18 false, hence denied by this defendant. The allegations noticed to which such and such all are denied. Sometimes general denied or sometimes specifically denied. But there is no such admission. From the written statement, it has not been stated that there is any admission of any of the allegations, contentions made in the plaint regarding reasonable requirement or notice or the deed. Everything have denied, specifically or otherwise. So there is no question of admission. Now, my lord, may I place the judgment. My lord, may I place the trial court judgment first? May I start from page 3 of the paper book, internal page 3.
You are placing the judgment of the trial court.
Of the trial court. Yes, ma'am. The premises was worn out and dilapidated, and the tenants was not paying the rent. Further, the owner Sebath, having no means and capacity to maintain this premises in habitable condition, decided to sell the premises, and in pursuance of the then owner agreed to purchase for sale Sebath, including the present opposite parties and their mother, now deceased, and entered into an agreement to sell the premises to the petitioner landlady by a registered deed of conveyance after obtaining lawful possession from the learned district judge. Lawful permission, my lord. There is no such permission I have stated, my lord. Thereafter, owner Sebath applied before the learned district judge at Alipur court for permission to sell the premises to intending purchaser, stating therein that the premises is worn out and dilapidated, b, the owner Sebath had no capacity to maintain the premises by making through repair, c, and lastly, the income of the property is meager. When the learned district judge at Alipur, on hearing the parties granted permission to sell the premises to intending purchaser, the petitioner of the on the basis of as is where is basis on the existing monthly tenant in common. The owner Sebayat being permitted by the learned district judge sold the premises number 13C Rajendra Lal Street by executing the registering legal proper sale deed and assigning the area rent as the existing tenants are defaulted since November 2000 and delivered the symbolic possession of the sold premises with tenants to the purchaser, which assignment of areas of rent being the unpaid rent. On an other after purchase being completed with delivery of possession of the sold property, the erstwhile vendors and the purchaser separately issued atonement letter and demanded letter to the existing tenants in common, directing the tenants in common to atone their tenancy and to pay their monthly rent with the arrears to the purchaser landlady. And for that relationship of the landlady and tenant in common were established in between the transferee landlord and the existing tenant in common by operation of law, and the same is binding upon the under West Bengal Premises in 1997. The last tenant, late Ranibala Dasgupta, now deceased, have inherited the tenancy comprised in premises number 13C Rajendra Lal Street, being two-storied building from their mother. On the demise of their mother, those 5 persons are the tenants in common are in occupation of the tenancy comprised in premises number 13C Rajendra Lal Street, PS Narkeldanga, Kolkata. But in spite of receiving the atonement letter, they have not paid the rent to the transferee landlord, and further since March 2005, from the month of tenancy remains as unusual, commencing from first day of every month of English calendar month for opposite parties tenant in common. Out and of the aforesaid 4 brothers, 2 brothers constructed their own house and are residing in their own house with their respective family, and has kept each brothers occupied same under lock and key since January 2002 and are not paying the rent. Thus, the tenants have not paid the current rent to the purchaser landlady, nor they have paid the arrears due being unpaid since November 2000, and opposite parties defaulters since November 2000 as WBT Act 1987. The opposite party number 1 has got his own dwelling house in spite of the due service of ejectment notice dated 25/11/2005. As mentioned above, the opposite parties have failed and neglected to quit and vacate to make over vacant and peaceful possession of the Schedule A premises to the petitioner, but on the contrary, opposite party are still holding over possession of the Schedule A premises, and as such, the opposite parties are liable to pay damages or damages charges. The ground of ejectment of the tenant in common are as follows. The opposite parties are willful defaulter in the matter of payment of rents, are in arrears of rent on and from month of November 2000 till now. Out of the said opposite parties, 2 tenants in common are residing in their own dwelling house elsewhere from the more than 3 years, as they are residing in their own house and having kept the rooms under lock and key, and for that rooms are being damaged day by day and also liable for eviction as per law. The opposite parties are living in the tenancy, and iniquity of conduct which is a nuisance causes annoyance to the neighbors, including the landlady. The petitioner landlady and her family is reasonably required the Schedule A premises for herself, accommodation, her family. Hence, the suit was filed for ejectment against the defendant. The defendant duly entered appearance, filed the written statement denying all material facts. The defendant further stated that the plaintiff has no cause of action for this suit against the defendant. The suit is not maintainable at law and its present form. The suit is a chance suit, and at the same time it is speculative, harassing, malicious one. The suit is barred by principle of estoppel, waiver, acquiescence. The the description of tenancy as mentioned in the schedule of the plaintiff, and the suit is bad for partial determination of the tenancy since the entire premises number 13 by C Rajendra Lal Street was let out to predecessor of these defendants, late Ananto Dasgupta by Didan Sebayat of the DT Sri Sri Nikunjo Bihari Jiu Thakur. The plaintiff intentionally suppressed the deed numbers and the place of registration, which entered the registration was not completed till the date of presentation of the plaintiff. If it be taken that the Deed of conveyance was registered on 14th March 2005. The plaintiff cannot allege this defendant a defaulter in payment of rent from 2000 in absence of any assignment of arrears. However, following erroneous order passed by the learned court in course of disposal of the petition under section 7.2, this defendant have deposited the entire arrears in court. It is denied that the plaintiff ever got possession, either physical or constructive, of the premises or any portion thereof, since these defendants are thou through physical possession of the entire premises number 13C Rajendra Lal Street, and never they admitted the plaintiff as the landlady following so-called derivative titles she acquired by virtue of so-called erroneous deed of conveyance. The tenancy of the predecessor of the defendant started from the breaking period of the month. They cannot be said to be tenant from first day of last day to each month. It is a fact two brothers have left the premises for paucity of accommodation, but none of them has acquired his own house and kept their room padlocked as wrongly alleged. It is true no current rent has been paid to the plaintiff since she was neither accepted as owner nor the landlord by this defendant, but these defendants were not defaulted in payment of rent since November 2000, which was deposited in the office of the rent controller after refusal by postal tender by their actual landlord. The imaginary house, as mentioned in paragraph 9 and 10 of the plaint, does not belong to these defendants as wrongly alleged. The allegations made in paragraph 11 has already been specifically denied. The rest of the allegations made in paragraph 11 to be proved by the plaintiff, but these defendants have definite information that the premises where the plaintiff resides in her own use, and she has further building in the city of Calcutta in else vicinity. The alleged notice to quit is illegal, inoperative, bad in law, and insufficient to determine the tenancy of the defendant. The said notice was never tendered to or served upon these defendants. Thus the question of payment means profit cannot arise. Upon the pleading, the following issues are framed to adjudicate the disputes in between the parties. Is the suit maintainable in its present form? Is there any cause of action to file this suit? Whether plaintiff is the owner of the suit property, whether notice to quit is legal, valid, sufficient, duly served upon the defendant, whether defendants are defaulters, whether plaintiff reasonably required the suit premises. 7. Whether plaintiff has not reasonable nor suitable accommodation. Below paragraph issues below.
Issue number 3.
Issue number 1 to 7 is also whether plaintiff has not reasonable nor any suitable accommodation. Below, this issue is to be proved through commissioner. Issue number 7 below. Milord, from issue number 3 onwards is the main point. Even Milord, I have is the suit is maintained in its form and prayer. The maintainability also I have challenged, because if the permission is not there, deed is not valid, so that on that point suit is not maintainable. And thereafter the point of notice. All the issues are relevant, Milord, and touching our defense. What is our defense? All issues are covered. So I have written in the written statement, Milord. To prove their case, plaintiff adduced evidence. One Sri Avani Kumar Ghosh, husband of the plaintiff, gave evidence as PW1 and documents are marked exhibited. Deed of conveyance dated 13th March 2000. Page 12, Milord, the exhibited document.
Let us proceed to issue number 3.
Oh, as it is.
Internal page 15. No, not internal page 15.
11.
Page 15 of the paper book.
Page 15. Oh. Yes. Yes, my lord. Issue number 3. Whether the plaintiff is the owner of the suit property. My lord, issue number 3, the defendant had raised the issue that the plaintiff number 1 not the owner of the suit property. The disputes was also raised by the defendant at the time of disposal of the petition under Section 7(2) of the West Bengal Constituency Act. The court, after due consideration and documents in the record, held in order number 38 dated 18th November 2010, the plaintiff is due owner of the suit property and have purchased the same after obtaining the permission from the learned district judge, as it is required in case of Devattar property. Hence, to discuss and again deciding the same issue is not necessary. Nevertheless, the defendant has filed the original deed Exhibit 1 dated 14th March 2005, duly registered at the Register of Assurances, Kolkata, executed in between plaintiff and trustees of the deed Sri Sri Nikunj Bihari Thakur. The recitals of the deed clearly mention the order of the learned district judge in miscase number such and such, giving permission to the sale to the property to the plaintiff. Since the defendant has raised the issue of onus is proving the negative is squared upon him, which he has not discharged by any cogent evidence. Prima facie, the plaintiff has shown better title than that of plaintiff. Hence, it is natural to hold the plaintiff is the owner of the suit property. This issue is decided in favor of the plaintiff. Now, my lord, as I have categorically submitted that in absence of that specific permission given by the district judge, this deed is absolutely invalid and null and void ab initio, my lord. And in this issue, learned court below state that this issue is already decided in the 7(2) at the time of disposal of the 7(2) application, so it is not necessary to decide further. But this is also wrong, because, my lord, the order passed in the 7(2) application is a tentative one. Final decision is the suit. So the issue should be decided thoroughly at the time of trial, my lord. But learned court below state that this issue is not required to be decided, but however he has decided and state that there is an exhibit, that is the deed, but there is no whisper of that permission upon which the deed has been executed. Only the recital, only they have stated the recital state this reference, but that recital does not validate the deed until and unless that permission has been shown or executed.
In the deed, it is mentioned that White ordered passed in
Such and
miscase by the learned district judge. The deed is being prepared and it is being sold. But according to you, the permission has not been produced before the court. It has not been exhibited.
Not only me, but also is this case. It has not been denied, but they have not stated that I have produced. It has not been exhibited. But even in the order at the time of disposal of 70 application, that has not been produced. The lordship pointed out on the earlier occasion, only the deed was produced below. But upon which that permission upon which deed is prepared and executed, that has not been produced at the time of disposal of 72 applications.
But in the deed, the miscase number has been mentioned.
Everything mentioned, but it is the plaintiff BB to feed on to what prevents them to file it.
Produce the permission.
Yes, there is. If they have got the permission, they should produce. There maybe there's something has been stated in the deed such and such. If it is there, they should produce. There may be another things, another order not relating to miscase. It has been stated in the deed. I do not know. It is their baby to feed on. When the deed has been produced, then there is nothing prevent him to produce that permission, which is very essential for this case to purchase the Devattar property. In absence of that deed, in absence of that decree or that order, the entire deed is invalid in spite of registration.
In absence of the permission, the deed cannot be executed.
It cannot be. If executed, that is also bad in specific allegation. Now let issue number 4, my lord. That is, my lord, I think notice. Whether the notice to quit is legal, valid, sufficient and duly served upon the defendant. Issue number 4, any eviction notice, eviction suit under section 6(4) of the West Bengal Premises Tenancy Act is initiated with the issuance of notice to quit under the Act, intimating the defendant about termination of the tenancy, and further, according to the defendant, sometime to vacate the suit property, and failure to do so within stipulated time attracts legal action. Likewise, in this case also, the defendant was duly issued the notice to quit dated 25/11/2005 to the defendants. The apex court in various cases have held that a notice properly named, address and stamped, it remain not claimed by the addressee. The same is presumed to be a good service under section 27 of the General Clauses Act. My lord, in this point, my lord, may I pause one moment, that if the defendants reside in the said premises, then the notice is
Then that could have been taken
Could have
into
been.
consideration.
could have been, but
Wherein it has been admitted that the three of the
defendants
defendants are residing elsewhere, that cannot be presumed.
that cannot be presumed is rebuttable. Your lordship knows very well. Then I rebut this presumption. Article 27 of the General Clauses Act, through such presumption is rebuttable. The defendant did not deny the fact that the address mentioned is incorrect, nor any such evidence is laid to deny the fact notice was not properly. Hence, I hold the notice to quit is legal, valid, and sufficient, and has been served properly to the defendant. This issue decided in favor of the plaintiff. Now, my lord, again, my lord, this notice is within a year that I have categorically submitted. So, on that point of view, also the notice is bad. If the notice is bad, entire suit is bad. An eviction issue number 5, one of the ground for eviction, the defendant was defaulted in payment in rent. The defendant, after appearing in the suit, had filed the petition under section 7(2) WBT Act. The court, after due consideration, directed the defendant to pay arrears of rent. Accordingly, the defendant is liable to get protection under section 7(4) against eviction on the ground of default. I have paid the rent. This issue is now issue number 6. That is, my lord, I think commission.
Reasonable requirement.
Reasonable requirement. This is very vital, my lord. The other ground for eviction is reasonable requirement of the suit property of the plaintiff and its family members. The plaintiff, in his argument, stated at the present the plaintiffs are residing in the rented accommodation and they want to reside in their own property, which they have purchased but due to tenants, and the plaintiffs could not enjoy their property. Where the defendants stated in his argument that the plaintiff has alternative accommodation other than suit property. It has been previously decided in foregoing issues that the plaintiff is the owner of the suit property. It is but natural for any owners to stay in his property. Likewise, the plaintiff, with his intention, have filed this suit that after evicting the defendants from the suit property, the plaintiff can stay in the suit property with her family members, which consist of her husband and 2 of her children, and a girl and a boy who are of age and require separate rooms, plus the plaintiff requires on living rooms, 1 storeroom cum kitchen, 1 thakurghar besides room for the avocation of her children. The defendants denied plaintiff such requirement and also stated the plaintiff has not filed any such documents to establish the need of children. Further, the plaintiff does not reside in a rented accommodation, have an alternative accommodation. My lord, I have specifically denied that learned court hold. The defendant denied plaintiff such requirement and also stated that plaintiff has not filed any such documents to establish need their children. Further, the plaintiff does not reside in a rented accommodation, have an alternative accommodation. Therefore, my lord, I never admitted the reasonable requirement anywhere. Rather, I denied. And also state that, as I have earlier argued, that they have another, the plaintiff has got another accommodation. So there is no question of admission that the plaintiff has got reasonable requirement. Never. The suit property consists of 4 rooms with 2 kitchen upon 2-story structure. No prayer for local inspection was paid. No prayer for local inspection was paid, but accommodation stated by the plaintiff is not denied by the defendant. Milord, there is whimsically, Milord, in the before paragraph, I have denied learned court hold, but in this paragraph, learned court hold I have not denied. In the written statement, I have pointed out that I have denied, generally or specifically or otherwise. He said the suit property consists of 4 rooms with 2 kitchen, 2-story structure. No prayer for local use was paid, but the accommodation stated by the plaintiff is not denied by the defendant. Is absolutely wrong proposition, Milord. By the defendant, thou the defendant has stated the accommodation in which the plaintiff is presently staying is not rented in alternative accommodation of the plaintiff, but such is not proved by any cogent evidence. And whereas the plaintiff has filed exhibits 7 and 8 to establish his fact that the plaintiffs are residing in the rented accommodation in spite of having her own accommodation as owner to the suit property, but due to tenants that they are unable to enjoy the same, the number of rooms existing in the suit property and demand made by the plaintiff for a requirement is not financial but fanciful but genuine need required for normal middle class family today, the modern day society. The court, while deciding the issue of reasonable requirement, has also to consider the hardship of the tenant in question. The defendants are 3 brothers who are at present staying in the suit property, and defendant number 4 is the married daughter of the original tenant, that is Father Ananta Kumar Dasgupta. It is stated by the plaintiff that the defendant number 1 has acquired his own property, which is denied by the defendants, but the plaintiff, in order to establish his case, has filed Exhibit 11, a certified copy of the deed dated 20th June 1989 in the name of Pankaj Dasgupta for having alternative accommodation. Such documents cannot be denied by this court of no concern. Evidence is filed to conduct such claim of plaintiff. The Exhibit 12 is an assessment register filed to establish the fact that defendant number 2 has retired from bank, also has property in his name, but such assessment register cannot be given much legally. The plaintiff have also stated that defendant number 4 was also working in state government hospital and residing in the quarter there. These facts and situation clearly indicates that the defendant are at all ways established in their avocations and paying merely ₹100 as rent for accommodation of 4 bedrooms, 2 kitchen situated at the premises, which is imaginable in today's society where price index is high. Now, my lord, thing is this: even the defendant had means to afford a higher rent, a owner cannot be denied, such as that. My lord, the reasonable requirement thing is this, that I have repeatedly argued that the commission work is sine qua non, indispensable for proving the reasonable requirement, until and unless it is ex parte hearing. If it is ex parte, without any written statement, without any defense, there may be reasonable requirement can be proved without commission work, without any commission report. But when it is highly contested, when it is denied in the written statement, specifically or otherwise, the reasonable requirement, then the commission work is absolutely necessary, my lord. Absolutely necessary. In absence of commission work, no clear picture would be in the learned court below, but learned court below hold without considering any commission report that this is sufficient. But we are going that this judgment, where learned court below in one paragraph hold, I have not challenged, but in the earlier paragraph, learned court below hold, that I have challenged. Then, my lord, on that ground, learned court below pass the decree. Now, my lord, may I placing the Now, my lord, may I placing the judgment of lower appellate court, my lord. Now, my lord, on and from page 38, these are with reasons. May I place, my lord? Page 38 of the paper book, my lord. Yes. Decision with reasons. Now the appellants have challenged the legality and propriety of the impugned judgment and decree mainly on three grounds. A, that the learned trial court erred in holding that the respondents was the lawful owner of the suit property having right, title and interest in the same. B, that the notice for ejectment was legal and valid and that the tenancy was terminated by the said notice. And C, that the respondent reasonably required the suit property for the personal use and occupation herself and her family members. So far as the ground relating to the right, title and interest of the respondent in the suit property is concerned, it is submitted on behalf of the appellant that it is an admitted position of the suit property was a Devottar property, and as such for the sale of the same there is a requirement of permission from the court of the learned district judge South Chobbish Pargona. In the present case, it has been asserted in the plaint that such permission was obtained from the court of the learned district judge South Chobbish Pargona. In the present case, it has been asserted the plaint that such permission was obtained from the learned district judge South Chobbish Pargona, but the respondent did not mention in her pleading about the details of proceeding in which the said order was alleged to be passed by the learned district judge South Chobbish Pargona, and the alleged order has not also been placed on record in the suit. It is submitted that the suit property being a Devottar property, the same cannot be sold without permission of the learned district judge, and any such transaction without such permission would be void and bad in law, and no title can pass under such transaction made without obtaining the permission in question. But the trial court totally overlooked the said fact and erroneously decided that the respondent is the owner of the suit property on the basis of finding arrived at the time of disposal of the application under section 7(2) of the West Bengal Proceedings Act 1987. It is submitted that the decision arrived by a civil court while deciding an application under section 7(2) of the West Bengal Proceedings Act is an interlocutory order, and the same cannot be taken into account while deciding an issue at the time of final disposal of the suit. In this regard, the learned counsel for the appellants relied on the decision of the Honorable Calcutta High Court in the case of the Nand Gopal Das versus Rabindranath De, and another reported in 1987 1 CHN 362, and in the case of Ramaprasad Bajaj and others versus Development Builders Limited and others reported in 1991 1 CHN 443. It has been further submitted that the learned trial court also erroneously placed the burden of proving the fact that the respondent has no right, title and interest in the suit property on the shoulder of the appellants, and prima facie held that the respondent has been able to prove a better title in the suit property than the appellants. It is also submitted that the learned trial court was satisfied about the existence of the permission of the learned district judge, South Chobis Pargona, merely on the basis of a fact there is some recitals in these regards in the title deed of respondent being deed of conveyance dated 14 March 2005 Exhibit 1 and did not care to look for the actual order in question to be assured about its existence. On the above score, the learned counsel for the appellant held that the finding of learned counsel for the appellant held that the finding of the learned court in respect of this issue is erroneous and the learned court should have decided the said issue against the respondent. On the other hand, the learned counsel for the respondent submitted that there has been no irregularity or illegality in the decision of the learned trial court and the learned trial court had, after considering all the facts and circumstances of the case and the materials on record, correctly came to the finding that the respondent had acquired lawful title over the property. That the learned counsel for the respondent submitted that the appellants are not entitled to challenge the title of the respondent in the support of being stopped under Section 116 of the Indian Evidence Act. In this regard, the very first question that poses itself for determination is that whether the appellants have a right to challenge the title of the respondent in the suit property, whether Section 116 of the Indian Evidence Act poses as a bar to the said right of the appellant. In this case, Subhash Chandra versus Muhammad Sharif and others reported in year 1990, Supreme Court 636. The division bench of the Honorable High Court has held in para 7 a judgment that it is true that the doctrine of estoppel applies where the tenant has been let into possession by the plaintiff, where the landlord has not himself inducted the tenant in disputed property and his right are founded on a derivative title. This position is a little different. A tenant already in possession can challenge the plaintiff's claim of derivative title, showing that the real owner is somebody else. But this is subject to rules enumerated in Section 116 of the Indian Evidence Act. This section does not permit the tenant during continuance of the tenancy to deny that his landlord had at the beginning of the tenancy a title to the property. The rule is not confined in its application to cases where the original landlord brings an action for eviction. A transferee from such landlord cannot claim the benefit, but that will be limited to the question of the title of the original landlord at the time when the tenant was let in. So far, the claim of having derived a good title from the original landlord is concerned, the same does not come under the protection of the doctrine of estoppel and is vulnerable to challenge. The tenant is entitled to show that the plaintiff has not, as a matter of fact, secured a transfer from original landlord or that the alleged transfer is ineffective for some other valid reasons, which renders the transfer to be bad in the eye of law. In the case at para 10 of the division bench of the Honorable Supreme Court also discussed about the judgment of 3 judges bench of the Honorable Supreme Court in case of Tejbahar Madan versus Second Additional District Judge and others reported in year 1988 Supreme Court 1413 and observed that in the case also the Honorable Supreme Court had opined that the derivative title may be challenged by the tenant. In case of Sambhunath Mitra and other versus Hoitan Consultant Limited and others reported in year 2005 Calcutta 281, the division of the Honorable Calcutta High Court relied on the judgment of Subhash Chandra Supra and observed at para 55 of the said judgment that where the old tenancy continues notwithstanding atonement, the tenant can always contend that the tenant who claims himself to be the landlord has not derived title from the original inductor. In view of the above discussion, it can be said that the appellants have the right to challenge the title of the respondent in the suit property and the said right is not barred under the principle of estoppel as envisaged under the provisions section 116 of the Indian Evidence Act. Moreover, in the case of Satyabrat Bose versus Omiyobala Bose and others reported in year 1984 Calcutta 392, the Honorable Calcutta High Court has observed that in a suit for eviction, the burden of proof is on the landlord to prove his ownership to the suit property, notwithstanding the provision of section 116 Evidence Act. So, in the case at our hand, the respondents were bound to prove before the court that she had purchased the suit property from the trustee of the said property, and the sanction or permission of the learned court district judge was obtained in regard to such purchase, and that there was no defect in the said title. It appears from the cross-examination of the PW that Abani Kumar Ghosh that the respondents had in her possession the certified copy of the order of the learned district South Chobis Parganas passed in respect of the premises to sell the suit property. But for the reasons best known to the respondent, she did not file the said documents before the learned court. In my opinion, the trial court erred in relying on the recitals of the title deed of the respondents Exhibit 1 to be satisfied about the existence of the permission of the learned district judge South Chobis Parganas regarding sale of the suit property, without perusing the actual order in question. Their mere mention in the recital of the title deed of the respondent exhibit about the existence of the order of the learned district judge in regard to the sale of the suit property would not suffice and cannot be substituted on the need to produce the actual order in question to discharge the burden of proof that lay on the respondent to show that she had a valid title to the suit property. Accordingly, I cannot agree with the observation made by the learned trial court in this regard and hold the same to be erroneous and not sustainable one in the eye of law. The respondent has failed to show that she has a valid title over the suit property. However, it is observed that I also cannot agree with the view of the learned counsel for the appellants that the learned trial court decided the issue regarding the right title and interest of the respondent in the suit property solely on the basis of observation made by the said court while disposing the application under Section 7.2 of the West Bengal Presidency Act 1997. It is a fact that there is observation made by the learned trial court that as it has already been decided that the respondent is the landlord of the suit premises. As such, there is no further need to determine the said matter, but the learned trial court also made its independent observation in dealing with the said issue and did not conclude the matter only on the basis of earlier findings. The next episode over which the learned counsel for the appellant tried to impeach the impugned judgment and decree is that notice of ejectment is illegal, void, inoperative, bad in law, and no termination of tenancy could be effected by such notice. The learned counsel for the appellant submitted that in this case, the notice to quit was issued on 25th November 2005 and the respondents has allegedly purchased the suit property on 14th March 2005. And as such, the notice of ejectment was issued within a period of 1 year from the date of alleged notice of title by respondent, and accordingly the said notice is bad in law. Learned counsel for the appellant submitted that as the respondent is alleged to be an owner by way of transfer, as such she was not entitled to issue a notice to quit on the ground of reasonable requirement in terms of Section 6.2 of the West Bengal Presidency Act within 1 year from the date of her alleged acquisition of title in the suit property. According to the learned counsel for the appellant, valid notice to quit is condition precedent for institution of a suit for eviction. It is submitted that when the notice to quit is issued, the ground for eviction should be available to the landlord, and if the same is not available to the landlord, then the said notice would be bad and inoperative, and accordingly the learned counsel for the appellant submits that the suit is liable to be dismissed for want of a valid notice. On the other hand, the learned advocate for the respondent submitted that the embargo as envisaged is is in respect of institution of the suit, and the same is not related to issuance of notice of ejectment. It is submitted on behalf of the respondent that the ejectment suit 52 of 2006 has been instituted on 6th April 2006, and the respondent had purchased the suit property on 14th March 2005. And as such, it is clearly apparent that the suit has been instituted after a lapse of 1 year from the date of acquisition of title by the respondent in the suit property. And as such, the instant suit has been filed after complying with all the requirements of the profession of law. It is submitted that the notice in question is legal, valid, there is no defect with the notice in question. Relying on the decision of the Honorable Andhra Pradesh High Court in the case of Paleti Shiv Ramakrishna versus Executive Engineer NCC, Colonel reported in AIR 1978 AP 389, the learned counsel for the respondent submitted that where no issue had
in AIR
AIR 1978 Miller.
78.
Yes, Miller. Yeah, written AIR 1908, it should be 1978 AP 389.
Okay.
The learned counsel for the respondent submitted that where no issue have been framed in the suit in relation to the legality and validity of the issue, the defendant would have been deemed to have waived the notice, and where no such arguments have been taken in the memorandum of appeal, no such grounds have been taken in the memorandum of appeal, such point cannot be allowed to be raised for the first time during the hearing of argument in the appeal. Now, the instant suit was instituted by the respondent for eviction of the appellants from the suit on the ground of default reasonable requirement. The appellants got the protection from eviction on the ground of default in terms of Section 7 of the West Bengal Presidency Act, and the learned trial court decreed the suit in favor of the respondent, holding that the respondent and her family members reasonably requires the suit for their personal use and occupation, but Section 6, subsection 2 of the West Bengal Presidency Act 1997 clearly forbids the institution of any suit for ejectment on the ground of reasonable requirement by a landlord who has acquired title to the suit property by way of transfer within 1 year from the date of acquisition of title. In the case at hand, the respondent had acquired the alleged title to the suit property on 14th March 2005, and the instant suit has been instituted 6th April 2006. So there is no doubt that the suit has been instituted after the expiry of 1 year from the date of acquisition of the title by the respondent in the suit property. But admittedly, the notice under Section 6(4) of the West Bengal Presidency Act 1987 Exhibit 13 has been issued on behalf of the respondent on 25th 11/2005, which means before the expiry of the period of 1 year from the acquisition of the title in the suit property by the respondent. So the question that appears before this court for determination in this appeal is whether such a case where the suit has been instituted after 1 year from the date of acquisition of title by the transferee landlord, but the notice has been issued prior to the lapse of 1 year, the suit can be said to be maintainable in law or not. In this case, Amarnath versus Sanjeev Das reported in 2008 CHN 962. 962, it has been held that a valid notice to quit upon the tenants is a precondition in a suit for eviction. Again, in the case of Mrs. V. Aviat versus Malik Zafar Ahmed, reported in 1987 to CHN 436, the Honorable High Court has held that even though the ground of ejectment need not be set out in the notice, yet the ground must be existing and available when the notice was issued, my lord. May I get the emphasis on this point that High Court has held that even though the grounds of ejectment need not be set out in the notice, yet the ground must be existing and available when the notice was issued. This is very important. And if there is no ground for ejectment, and if a notice is still issued, that would be ineffective. This is very vital, my lord, for our case. because it is not the intention of the legislature that the notice should be an empty barrel. In the present case, as already observed, the suit was decreed on the ground of reasonable requirement of the respondent on the basis of notice issued by the respondent on 25th November 2005. But as the respondent had acquired title in the suit property by virtue of the deed of conveyance dated 14th March 2005, as such, on the date of issuance of the said notice, she did not have the ground of reasonable requirement available to her on account of embargo as mentioned in section. This is also very vital because at that point of time when notice was issued, there is no such ground. So the notice is entirely bad in law. As such, the present case, the notice dated 25th 11/2005, Exhibit 13, cannot be said to be a legal, valid one, and the same cannot be sufficient to terminate the tenancy in question. The learned trial court, while dealing with the issue relating to the legality, validity, and sufficiency of the notice dated 25th 11/2005, Exhibit 13, only concentrate on the point regarding its proper service and did not give due consideration to the question in respect of its legality, validity, sufficiency to terminate the tenancy in question. It has been observed by the learned trial court that no evidence has been laid to deny the fact that notice was not a proper one. In my considered opinion, the learned trial court erred in law in this regard, as the question regarding legality, validity, and sufficiency of the notice is not a question of fact, but a question of law, and no evidence was required to be laid to determine the said question. Further, it is also erroneous to hold that there has been no denial on the part of the appellant regarding the fact that the notice was not proper. In paragraph 17 of the written statement, the appellants have clearly asserted that the alleged notice to quit is illegal, inoperative, bad in law, and insufficient to determine the tenancy of the appellants, and the trial court itself framed the issue regarding the legality, validity, sufficiency of the notice in question. The decision of Honorable Andhra Pradesh High Court in the case of Paleti Shiv Ram Krishnath, relied on by the learned counsel for the respondent, cannot come to the help of the respondent, as in the instant case strong objection has been taken in the written statement regarding the legality, validity, and sufficiency of the notice in question. An issue has also been framed in this regard. So it cannot be said that the appellants have waived the objection relating to the notice, and they cannot be permitted to put forward the said ground in this appeal. As the statutory notice in this suit is found to be invalid and bad in law, as such, whole base of the suit suffers from severe irregularity and the suit is bound to fail. Another aspect that has been taken by the appellants to impeach the impugned judgment and decree is that the learned court was erroneous in holding that the respondent and her family members reasonably required the suit premises for their personal use and occupation. Much debate has been made on this point. After 2 page, may I please? This is not vital for. Yes, Milord. Ordered. Page 56, Milord. Ordered that the instant. Now, what page 50, second paragraph. Milord, may I place the page 55, second paragraph?
Now in view.
Now in view of the entire facts and circumstances stated above, it can be concluded without any hesitation that in the present suit for eviction, the essential condition precedent regarding existence of a valid and legal notice to quit is found to be absent, and as such the instant suit cannot be said to be maintainable in law, in facts, and the learned trial court made serious error in decreeing the suit in favor of the respondent by not considering the above fact regarding the absence of a legal proper notice to quit in this suit. The impugned judgment and decree suffers seriously from non-application of judicial mind on the part of the learned court below and is required to be interfered with in exercise of the appellate jurisdiction of this court. This appeal preferred by the appellant has sufficient merit and calls for a favorable response. The memo of appeal is properly stamped, hence it is ordered that the instant appeal be and same is allowed on contest against the respondent ex parte against the pro forma respondent, but without any order as to cost. The impugned judgment and decree dated 29th February 2016 passed by the learned court, Civil Judge Junior Division First Court Sialda in the ejectment suit number 52/2006 is hereby set aside, and it is hereby ordered that the said suit be the same is dismissed on contest. Let a copy of the order. Therefore, my lord, on the point of notice, the learned appellate court below favoring us, deciding that the notice is absolutely bad, on the ground that there is no such ground available at the time of institution of the notice. Notice is within a year, and more or less, this notice is the indispensable part of a suit, especially the eviction suit. Without notice, eviction suit cannot be started. Even the notice is the part and parcel of that note of the eviction suit, of the plaintiff. Until and unless notice is served, the plaintiff is not filed. So, the eviction notice is first initiation of the suit. Eviction notice is the pillar of the suit. Eviction notice is prima facie documents, is the mandatory in law under the West Bengal Premise Tenancy Act. Therefore, if the said notice is bad, if the said notice is given within 1 year from the date of purchase, the notice is itself bad in the eye of law. So, this so the appeal is succeed before the learned appellate court, and my lord, all the judgments I have the learned appellate court relate, I have also reliance of the same judgment. My lord, in the same day I shall place the judgments today.
You are stating that you are relying upon all the judgments which have been
Yes.
placed by the
Appellate court, and my lord,
council before the first appellate court.
may I, in addition to that, may I place some judgment regarding admission? That is, my lord, my lord,
Next day means it is indefinite.
Very
That's why
answer.
it is becoming a problem for me.
Very answer.
which is the my lord. Ma'am, it's my children.
Here about 10 judgments have been cited in the
I
judgment
have
of the
got
first
full
appellate.
reliance on it, except by junior some.
In addition to those, any other?
My lord, supervised submission of my landed senior pay, landed type of appellate, my lord, submitted to one judgment, my lord, wherein, my lord, division bench says, my lord, that, my lord, notice is, suit is bad. Suit cannot be filed within a period of 1 year, but notice can be issued. But so far that point is concerned, my lord, that is a distinguishable, my lord, another division bench judgment of this honorable court, my lord, which says, my lord, no. But if the notice is
Cannot be issued.
notice cannot, because on the date of issuance of the notice and on the date when the cause of action arose, you do the law prohibits you, my lord, seeking eviction on the ground of disorderly conduct. My lord, in the instant case, my lord, my landed client, my lord, purchased the suit property on 14 March 2005.
You have relied upon one
Yes.
CLT,
Reported in Calcutta law times.
Calcutta Law Times, page 48.
Yes.
One CLT, page 48.
My lord. My lord, prior to that, my lord,
Honorable Justice Monoranjan Mollik.
Yes.
Most probably.
Monoranjan Moldik and Manobendra Nath
Yes.
Roy.
Division.
prior to that, I'm coming to that point, my lord. Let me place the, my lord, the first point. So far as the, my lord, the ownership is concerned, my lord, the learned trial judge, my lord, came to the conclusion on the basis of the, my lord, decision arrived at under section 7.2. So since the landed court below came to the finding in the under section 7.2 that he is the owner of the property in question, and on the basis of that, no further explanation, no further decisions on at the time of trial.
As has been decided while disposing of 7.2, no further discussion is required.
No further so far that part is concerned, my lord, I am relaying the decision of this honorable court. 2006, volume 3 CHN. All right. This is one, my lord. 2006, volume 3 CHN, page 689.
2006.
Volume 3 CHN, page 689. Paragraph 25.
Page
689. Paragraph 25, my lord.
Yes.
We find from the materials on record that the learned trial judge has not arrived at any independent conclusion as regards the allegation of default in payment of rent at the time of final hearing, but has relied upon the observation of the revisional court while disposing of a revisional application preferred against an order passed under section 17(2) of the West Bengal Premises Tenancy Act. In the written statement, the appellant has specifically taken the plea that the monthly rent of that was rupees 2,000, and apart from payment of that amount, it was under no obligation to pay any amount of corporation tax or surcharge imposed by the corporation. Such plea was also taken in the application under section 17(2) of the West Bengal Premises Tenancy Act. The learned trial judge did not arrive at any independent conclusion on the basis of evidence adduced in this case at the time of hearing of the suit as regards the rate of rent payable by the tenant. It is now settled by various decisions of the division benches of this court that any finding made at the time of disposing of the application under section 17(2) of the West Bengal Premises Tenancy Act will not be binding upon the trial court at the time of trial, and the earlier finding made at the time of disposing of the application under section 17(2) of the Act should be treated as to be a tentative one for the purpose of disposing of such application only, unless the relevant issue of default or relationship of the parties was also decided along with the application under section 17(2) of the Act. And synthetic plywood reported in such and such, where all the decisions on this point have been referred. So, my lord, my contention is that, my lord, so far the ownership part is concerned, court has come to the conclusion only on the basis of, my lord, decision arrived under section 7.2. And in the set 7.2, my lord, if you lordship visualized in this way, suppose, my lord, a general property is purchased. In that event, my lord, if the deed is placed, my lord, then it will be marked an exhibit and that is to be relied upon. But in the facts and circumstances of the instant case is something else. Here, my lord, this is a Devotta property. You are to fulfill another precondition, my lord, to satisfy the learned court, my lord, that you have the owner, you are the owner of the property in question. And to that extent, my lord, you are to prove before the court that yes, you have got sufficient permission from the learned district judge. That has not been, my lord, has not been fulfilled by the plaintiff hearing. So, my lord, the decisions so far, the ownership is concerned, my lord, that has been arrived by the learned trial court, my lord, that is, my lord, erroneous one, my lord, that is not sustainable in the eye of law.
Not ownership, one of the criteria for selling part of the property.
Selling part of the property. This is, my lord, very vital. And, my lord, learned he has stated, my lord, in the pleadings also, but he has not, my lord, produced it by marking the document. This is a very vital document of the ownership. Unless and until that comes to the, my lord, court, my lord, his deed, my lord, cannot stand. This is
Everything has been stated, but physical presence of that document is not there.
My lord. But that is a signing honor. because this is not a general property, this is a devoted property. You have to prove, you have to produce this. You have to mark this as an exhibit. Otherwise, the document cannot be fully relied upon. Only recital will not do. And in the instant case, then I am coming to the point of the notice. The suit property was purchased, on 14th March 2005. Kindly mark this, 14th March 2005.
All those have been dealt with by his learned CP. Repeatedly.
Page 12, page 5 of the paragraph 12, that the petitioner through our authorized agent advocate is Sudhanshu Shekhar determined the tenancy by an ejectment notice under section 6(4) of the West Bengal Pension Act dated 25th November 2005. So, notice of ejectment was issued on 25th November 2005. Suit property purchased on 14th March 2005. And I was directed and to vacate and deliver the vacant peaceful possession of the tenanted premises known as scheduled at premises with the expiry of the last day of the month of December 2005. And the said notice was specifically sent and such members of the was registered with AD. And the cause of action of the suit arose. Paragraph 17 of the plaint. That the cause of action of the instant ejectment case arose on and from 1st day of January 2006. 14 March 2005. Suit property purchased. Cause of action for filing the suit was arose, on 1st January 2006. So, it is within 1 year. When there is an embargo under section 6(2), after purchase of the suit property, I am placing where a landlord has acquired his interest in the premises by transfer, no suit for the recovery of possession of the premises on the ground of requirement for building or rebuilding or addition, alteration or requirement for own occupation. These 3 grounds shall be instituted by the landlord before expiration of a period of 1 year from the date of acquisition of this interest. So, this embargo prohibits the plaintiff landlord, to institute a suit. Here, what my contention is that, whether you will file a suit or not, that is up to you. I cannot resist you from filing a suit.
But cannot be instituted within 1 year.
Can we institute 1 year? Then, in a eviction suit, notice is the basis, is a precondition for filing. If the notice is bad, suit bad. Now, on the date of cause of action on 1st January 2006, the cause of action was filing the suit on the ground of reasonable requirement. Your cause of action statute bars you from making any cause of action on the before expiry of 1 year. Here you are stating on oath in the plaint that the cause of action for filing the instant ejectment suit on 1st January 2006. So, on the date of cause of action for filing the suit, the ground of reasonable requirement was not there, because the statute bars you from filing the suit. You are stating that the filing of suit, cause of action arose on 1st January 2006. So, on the date of cause of action, the ground of reasonable requirement was not there. If you lost it visualized in this way,
The landlord is barred from instituting the suit.
instituting the suit. Here, my contention is that, notice is bad. If you lost it visualized in this way, suppose, landlord issues a notice, apart from on the ground of reasonable requirement or building, rebuilding, suppose on the ground of default or subletting. In that event, I have nothing to say.
Counsel, the remaining portion after recess. I also have
Continue. Item 5.
So far, my lord, the notice point is concerned. Whether the notice is bad or not. Statute says suit cannot be filed within 1 year. Statute does not say that notice cannot be issued. Statute does not say so, but says the suit cannot be filed. In the instant case, suit filed after expiry of 1 year, but notice is issued prior to expiry of 1 year. My contention is that, my lord, notice is the basis of the suit. If the notice is bad, illegal, suit goes. Suit is not maintainable. If your lordship visualize in this way, suppose a notice is issued. Now today is 10th February. Today eviction notice is issued directing the tenant to vacate the suit premises without giving 1 month notice. That means, my lord, expiry of March. Suppose he is directed today 10th. Suppose he is directed to vacate the suit property by 28th March. In that event, my lord, notice is bad because not entire 1 month has not been given. Irrespective of the fact, my lord, whether the suit is grounded on any of the grounds. Here, my contention is that, my lord, the notice is bad. Has it been a case? If in the instant case, suit is filed apart from any other ground on the ground of the building or reasonable requirement, I have nothing to say. Suppose, my lord, suit is filed on the ground of default and subletting prior to expiry of 1 year, and the suit filed after 1 year, it can be filed and the notice is good. But when there is an embargo that the landlord and the owner is stopped from making a suit prior to expiry of 1 year on the ground of reasonable requirement. Here the suit has been filed on the ground of default and reasonable requirement. Default ground, my lord, I got relief under section 7(4). Suit has been decreed on the ground of reasonable requirement. So the cause of action of the suit, here plaintiff says cause of action arose on 1st January 2006. 14 March 2005, suit property was purchased. So prior to expiry of 1 year, cause of action arose. My lord, if the cause of action arose on the ground of reasonable requirement, kindly mind this. In that event, my lord, whether decree can be granted on the ground of reasonable requirement after expiry of 1 year, that is a moot question to be decided by your lordship. And that, my lord, London Lower Appellate Court, my lord, has gone in my favor, relying the decisions of the division bench of this honorable court. My lord, in this matter, my lord, I am relying, my lord, on decisions of this honorable court. It is just, that is reported in, my lord, 74 CHN, page 48. My lord, kindly turn to page 49, next page. My lord, at the bottom, held. Page 49, my lord, have you also got it? Page 49, my lord, next page. My lord, it has not been mentioned, but subsequently relying this judgment, my lord, division bench has, my lord, passed. My lord, I have marked this. I am relying this second time. My lord, this judgment which I have handed over to your lordship, that has been, my lord, relied. I have marked this, my lord. Gangadhar, my lord. Page 48, my lord. Lord, kindly turns to page 49. My lord, it was dealt with, my lord, under the 1956 Act. My lord, I am reading, my lord, held. The grounds of ejectment have been provided for under section 13(1) of the Act, on the basis whereof only a court will have jurisdiction to pass a decree. The jurisdiction to decide a suit is further circumscribed by a condition which is the service of a notice of a suit as a condition precedent to the institution of the suit. If the suit cannot be decreed except on specific grounds, and no suit can be filed without such notice. So, my lord, notice was issued on the ground of, my lord, reasonable requirement. If the notice cannot be issued prior to expiry of 1 year on the ground of reasonable requirement, my lord, suit fails. So, the ground of reasonable requirement was not existence on the date of issuance of the notice. Here, my lord, the cause of action arose on 1st January 2006. Plain case. It is only without no such notice. It is only obvious that the grounds must be in existence when the notice is issued. In the instant case, my lord, when the notice was issued, the ground was not available to the plaintiff landlord. The landlord will not otherwise be entitled to serve a notice of suit unless the grounds of eviction which would give the jurisdiction to court to pass a decree are already there before issue of notice. It is also obvious that the tenancy has to be determined along or before the notice of suit. On the determination of the tenancy, there would be no legal liability of the tenant to tender rent to the landlord, and there would be no scope for deposit of rent with the rent controller. There would be no occasion for default after service of the notice determining the tenancy and the notice of suit, the grounds of such. Here, my lord, it, my lord, dealt with on a different except on the ground of, my lord, default. Here, my lord, so, my lord, what, my lord, I am calling, it is calling out from the instant judgment whether, my lord, here, my lord, in another chapter, here, my lord, I want to show the principle of, my lord, law. My lord, on the date of issuance of the notice, on the termination of tenancy, my lord, there must be a ground on which the court can pass a decree on any of the grounds. But here, in the instant case, my lord, on the date of issuance and on, my lord, on the date of cause of action of the suit, the ground was not available to you. There is an embargo upon the, there is a embargo, my lord, by the statute that you cannot, my lord, file a suit for eviction on the ground of reasonable legal. While relying upon this decision, my lord, the division bench of this honorable court, my lord, that is reported in, my lord, 1987 to CHN. Page, my lord, 436. 36. Yeah. My lord, I am relying, my lord. Kindly straightway come to the one relevant portion, page 49, 439. 439, my lord. My lord, but 13 line from the bottom. Page 439, my lord.
Well, may I leave? Yes.
Page 439, my lord. 13 lines from the bottom. The notice, have you also got it? The notice as per section 13(6) of the Act must be based on grounds, and the suit itself must be based on the notice in the single bench decision reported in 1967 Calcutta page 390. It has been observed that the notice to quit is a condition precedent within section 6, rule 6 CPC, and should be implied in pleading. It has further been observed that it is also a part of the cause of action. With respect, we agree now. Now, if the notice is to be part of the cause of action, events subsequent to the notice cannot be relevant. The reasoning seems to be simple. The grounds of rejectment need not be set out in the notice, but the grounds must be existing and available for the issuance of the notice to quit. So, on the notice to quit, ground must be existing. In another single bench decision reported in 1974, volume 1 CHN, page 48, it has been clearly held that the grounds must be in existence when the notice is issued. His Lordship has observed that the jurisdiction to decide a suit is further circumscribed by a condition which is the service of a notice of a suit as a condition precedent to the institution of the suit. If the suit cannot be decreed except on specific grounds, and no suit can be filed without such notice, it is only obvious that the grounds must be existence when the notice is issued. So, my lord, when the notice was issued, the ground must be existing. Here, my lord, the ground of reasonable comment was not in existence.
Barred by the statute.
Barred by the statute. If the notice is bad, suit goes. Again, with respect, we subscribe to the view expressed by the learned single judge. The notice is intended to be effective. It must be able to effectuate the end for which it was issued. If there is no ground for rejectment, if a notice is still issued, that would be ineffective. It is not the intention of the Act that the notice should be empty barrel. That is why the reasonings of section 13(6) of the Act, the notice is to be based on the grounds existing and the suit is to be grounded on the notice itself. If post-notice default cannot be considered, the default for the month of August 1975 becomes irrelevant for the purpose of the suit. In that case, there is default for 1 month only. That is the month of July 1975. If there is a default for 1 month only, that does not enable the landlord even to file the suit under section 13(1)(I) of the West Bengal Pension Act. The suit for rejectment therefore was itself incompetent. The learned court below should not have passed a decree on such grounds. Here, my lord, the default was after, my lord, filing of the suit. In the instant case, when the notice was issued, my lord, there was no default. So, my lord, the ground of default, my lord, was not in existence when the notice was issued. That is the reason why, my lord, the court held, my lord, the notice is bad. Suit, my lord, is not maintainable. Mr. Pine, the learned advocate for the respondents, has referred to the decision reported in 67 CWN page 977. It was held in that decision that it was not necessary to mention in a notice under section 13(6) of the Act the grounds of rejectment for which the suit was to be instituted for recovery of possession. We have not observed that the ground must be set out in the notice, but we have made it clear that the ground, whether mentioned or not, must be existing on the date of notice is issued. Here, my lord, pause it for a moment. Suppose, my lord, I issued an eviction notice without, my lord, indicating the grounds, whether default, subletting.
Notice is notice to quit.
Notice to quit. Landlord need not, my lord, make the ground, on the ground of the. But if the court, my lord, wishes to pass a decree, my lord, that ground must be existing on the date of issuance of the notice.
On the ground the decree is to be passed, that should have existed
On
at the time of issuance of notice.
issuance of the notice and of the cause of action. Here, cause of action arose, my lord, prior to expiry of 1 year. Statute bars you from instituting the suit. Therefore, the decision cited by the learned advocate is of no assistance to him. Again, another decision, 71 CWN, page 686, has been cited by Mr. Pine. That decision reiterates the same principle, namely that the notice need not contain the grounds. We have already made our observations. With reference to that, the notice need not mention the grounds, but the grounds must be existing on the date of the notice. Having considered the materials on record, we find that the defendant has been a defaulter for 1 month only. So, my lord, it is in respect of that that context. The principle is that, my lord, on the date of issuance, the ground must be existing. My lord, this decision, my lord, 1987, my lord, CHN, my lord, this is passed by the division bench of this honorable court, consisting of Honorable Justice S.P. Das Ghosh and L.M. Ghosh, division bench. Now, my lord, my learned friend, my lord, has come up with a judgment, my lord. It is also, my lord, of division bench. Where is, my lord, this analogy, this principle of law has not been enunciated. Just only on the, my lord, literal meaning. Just only on the literal meaning says, should, since there was no embargo to issuance of the suit before expiry of 1 year, a suit can be filed after 1 year, after expiry of 1 year, so, my lord, suit is maintainable. Just literal meaning. No, my lord, discussion so far as the, my lord, the validity of the notice. I am placing the judgment which my learned can rely. My lord, kindly turns to page 53, my lord, relevant portion. Page 53. Have you also got it, the judgment? 92?
Yes.
92 volume 1 CLT, page 48.
Page 53.
Page 53. My lord, clause 3A of the act, just 3 lines from the above. Where a landlord has acquired his interest in the premises by transfer, no suit for the recovery of possession of the premises on any of the grounds mentioned in clause F or clause FF of subsection 1 shall be instituted by the landlord before the expiration of a period of 3 years from the date of his acquisition of such interest. This is the 1956 Act. Provided that a suit for recovery of possession of the premises may be instituted on the grounds mentioned in clause F of section 1 before expiration of the said period of 3 years, if the controller on the application of the landlord and after giving the tenant an opportunity of being heard, permits by order the institution of the suit on the ground that building, rebuilding and addition alteration, as the case may be, are necessary to make the premises safe for human habitation. This is, my lord, another context. Here, my lord, the embargo is, my lord, the owner, my lord, is stopped from instituting a suit on the ground of building, rebuilding and reasonable requirement. Earlier 1956 Act, 3 years limitation, and the present 97 Act is 1 year limitation. Now, paragraph 10, my lord, it is clear from the above provision that subsection 3A puts bar upon the landlord acquiring his interest in the premises by transfer not to file a suit for recovery of possession of the premises on any grounds mentioned in clause F, clause FF. F means building, rebuilding, and clause FF means reasonable requirement of subsection 1 before the expiration of a period of 3 years from the date of acquisition of such interest. The plain language of subsection 3A is there, no suit shall be instituted by the landlord. If we have to go by the plain language of the statute, it can be read in subsection 3A, the further embargo that the notice of ejectment under section 13(6) cannot also be issued upon the tenant before the expiry of the period of 3 years, when the statute on its plain reading does not put such embargo to a transferring landlord. Plain reading says, suit cannot be issued within a year. If you lost it, visualize in this way, suppose the landlord, my lord, purchase the property. He issues, my lord, eviction notice apart from the grounds under section building, rebuilding and reasonable requirement. He may, my lord, come up with default, he may come up with subletting or any other grounds as, my lord, embodied in the said section. My lord, in that event, my lord, he can issue notice, he can file a suit for eviction. There is no bar. But so far as, my lord, the ground of reasonable requirement is concerned, if your loss, my lord, visualize in this way, suppose, my lord, this suit is on the ground of default and reasonable requirement. If the court passes a decree on the ground of default, I have nothing to say. Because this embargo is not there. Suppose on twofold grounds, the instant eviction suit was filed before the landed court below. Default is not legal. Suppose, my lord, if the suit is, my lord, decreed on the ground of default, I have nothing to say so far the notice party is concerned. Because so far as the notice party is concerned, my lord, the landlord can issue notice prior to expiry of 1 year. But in the instant case, my lord, suit has been decreed on the ground of reasonable requirement. This ground was not available on the date of issuance of the notice and not the date of cause of action of the instant suit. And my lord, Mr. Shokinath Mukherjee, appearing for the respondent, has drawn my attention to such and such crisis on statute law, 7th edition, page 64-65, where it has been clearly observed that if the words of the statute are themselves precise and unambiguous, then no more can be expound those words in their ordinary and natural sense. And the words themselves alone be such a case best declare the intention of the lawgiver. That similar observation is found in Maxwell interpretation statutes. In this particular case, also the clear and unambiguous expression of the legislature contained in subsection 3A is to prohibit on only filing a suit for eviction on the ground of clause FF or clause FF of section 13(1) of the Act prior to expiry of 3 years. However, the embargo is not an absolute one. The proviso gives a right to such transponder to approach to the rent controller paying for permission to institute a suit on the ground of building, and the rent controller, after giving a tenant an opportunity of being heard, can give such permission. This is another aspect. Here, my lord, he has not approached to the controller, my lord, for taking permission. Here, my lord, he straightway come to the court and files such suit on the ground of default and reasonable requirement. So, my lord, this plain reading of the Act, the effect of the Act, my lord, this to be, my lord, gone into. Simply plain reading will not do, will not suffice the, my lord, the purpose. Here, plain reading says no suit can be filed. But there is no embargo of issuing notice. But if here my contention is that I am not saying that suit is since the suit has been filed, my lord, after expiry of 1 year. My contention is not that so far the suit is concerned. My contention is that notice is bad.
Got it. Next.
My contention is that notice is bad because on the date of issuance of the notice and the cause of action of the suit.
Action had not arisen at that point of time.
At that point of time, you cannot pass a decree on that ground also, because that ground was not available to the owner.
Being barred by statute.
Being barred by statute. So my humble submission before your lordship is that, my lord, this is a division bench which is, my lord, 87 CHN. My lord, it is based on, my lord, interpretation of law. Wherein, my lord, here, my lord, plain reading of the language of the section. My lord, in such a circumstances, my lord, there is a, my lord, special bench judgment of this honorable court. My lord, I am relying, my lord, 1989 Calcutta, page 120.
Yeah.
120.
120. Paragraph, my lord, 15. 15. My lord, this is a one copy, my lord. I am placing it and I hand over. My lord, this decision, my lord, is based on a, my lord, special bench judgment of this honorable court. My lord, that is 1988 Calcutta, page 1. Here, my lord, it has been, my lord, says this. My lord, I am reading. As has been pointed in a recent special bench decision of this court, in Bholanath Karmakar EIR 1988 Calcutta at page 6 to 7, while the confronted with conflicting decisions of the Supreme Court rendered by benches of equal strength, the High Court would have to prefer one to the other and is not necessarily obliged as a matter of course to follow either the former or the latter in point of time, but must follow the one which according to it is better in point of law. Which according to it is better in point of law. Needless to say that it would be quite embarrassing for a High Court to declare one out of two or more decisions of the Supreme Court to be more reasonable or better in point of law, implying thereby that the other or the others is or are less reasonable. But if such a task falls upon the High Court because of reconcilable contrary decisions of the Supreme Court emanating from benches of a coordinate
It's also a
jurisdiction.
division bench judgment. This is
My lord?
also a division bench judgment,
Yes, my lord.
not special bench. Division bench judgment.
My lord, I have not got this copy. A.M. Bhattacharya's judgment. Yes, my lord. And relied, my lord. Yes, my lord. My lord, this judgment, my lord, the year 1988 Calcutta, relying upon this, my lord, division bench, my lord, passes this. This is a special bench judgment. When kindly make it note it, my lord. The year 1988 Calcutta, page 1.
Achha. That is a special bench judgment.
Special bench judgment of this honorable court, 3 judges bench.
1988.
88 Calcutta, page 1. Where my lord, this principle has been held, my lord, is let down.
Yes, 3 judges bench.
3 judges bench. If there is a two decisions, conflicting decisions,
You are placing paragraph.
year 88 Calcutta.
Mm-hmm.
Well, I have to. This judgment is not
Achha,
with me.
which is
But relying this, well, this judgment, my lord, has been.
1989 has been.
Yes. Here, my lord, we are faced with. Here, my lord, we are faced with 2 division bench judgment. One is 1987 CHN, another is, my lord, 1992 CLT, which is referred by my learned senior judge. Which one we are to follow, but which is better in point of law? Which is better in point of law? 92 CLT, my division bench says literal meaning. Literal meaning says embargo in institution of the suit. No embargo of issuance of notice.
1988, 1989. Both were during the prevalence of the 1956 Act.
Yes.
1956 Act.
My lord.
19
Similar. Principle is similar.
1956 Act was on behalf of the tenants.
My lord.
Now it has changed drastically and it is now neutralized
Yes,
after the coming into effect of the 1997 Act.
grateful to you.
97 Act, 2000, 1956 Act, there is no, my lord, difference, my lord. Only the period. Only the period.
After going through that long period, seeing that it is being
Principle is same. My humble submission, principle is same.
it is being misused and the
Yes.
advantage is being taken by the tenants.
Yes.
The 1997 Act has come into.
Was an act.
My lord, in my humble submission, my lord, so far the principle is concerned, my lord, there is no, my lord, difference.
There is no difference.
I am, my lord, banking upon the principle laid down in the Act. Principle is that, my lord, on the date of issuance of the notice or cause of action, ground must be existing. Here, my lord, in the instant case, my lord, that is lacking. And the division bench of 92 CLT, my lord, has not dealt with this.
1956 Act came into being as because there was scarcity of accommodation.
For the people coming,
My lord, 1997 Act is also beneficial for the landlord as well as the tenant. My lord, is there, my lord?
And 1956?
Both. My lord, kindly consider this. We are only concerned about the principle of law.
Yes.
We are bound by
Absolutely,
law.
yeah.
We are bound by law.
Absolutely.
Whatever maybe we are not for the landlord, we are not for the tenant. Here, my lord, we are here, my lord, to do justice to the litigant.
Yeah, exactly.
And we are to,
exactly.
my lord, rely upon the principles laid down by the various decision of this honorable court.
Nothing beyond that.
Yes. Here, my lord, the principle is same. Because on the date of issuance of the notice or cause of action of the suit, my lord, this ground was not in existence, was not available to the landlord. So you cannot, that is the reason why I am making distinction. Suppose, my lord, the suit is filed on the ground of default and subletting. Suppose notice is issued and suit is filed after expiry of 1 year. My lord, in that event, my lord, if the suit is declared on any of the grounds, default or subletting, I have nothing to say. because the embargo of building, rebuilding and reasonable requirement was not there. Default or subletting. Court can pass a decree any of the grounds. But this embargo is there. On the date of issuance of the notice, the ground of reasonable requirement was not there, is lacking. Court making court barring you to institute a suit. Cause of action was not there, and no decree can be issued. My contention is notice is bad. Kindly find this. Notice is bad. If the notice is bad, consequence will follow.
That you can stress upon. That at the point of time when notice was issued, the landlord did not have the cause of action as because he was barred by the statute.
My lord.
That you can stress upon.
But that is I'm stressing upon. That is I'm stressing upon. And that has been done in the instant case. And my lord, so far as the point of law, here my lord, 92 CLT my lord court has not dealt with so far as the notice is concerned. I am not in state where suit is bad. I am not saying this. My contention is the notice is bad. You cannot pass a decree for eviction on the ground of reasonable requirement. That is my contention in the instant case. I am not saying that suit is bad. The consequence will follow.
Next point.
Now, my lord, so far the 92 CLT is concerned, my lord. My lord, I am relying upon this book, West Bengal Premises Tenancy Act by Sengupta.
I have in my residence, but not here.
Anyway, my lord, it will, my lord,
state
help.
the edition and page number.
My lord, I am telling you. Page, my lord, 638.
Which edition?
Edition.
SP Sengupta.
Sengupta, I am telling, my lord. SP Sengupta. 2013.
2013. Page
638.
638, yes.
Here, my lord, it has been discussed. So far, this point is concerned. If the notice is issued prior to expiry of 1 year and the suit is
Place
filed.
it, you place it.
Well, I have the copy. I have a copy. Well, can you have a look at this? I have a copy. My lord, head note 452, page 638 at the bottom.
Transferee landlord short ejectment within 1 year on different grounds,
including building, rebuilding or reasonable requirement for occupation. The embargo imposed by subsection 2 of section 6 prohibits the transferee landlord not to seek for eviction of his tenant under clause C or clause D of section 6(1) before expiry of 1 year from the acquisition of the interest of the landlord in the suit premises. Even if he sues after expiry but gave a notice under section 6 for within 1 year, the suit will be bad because cause of action must also exist on the date of notice. But a notice under section 6(4) is a notice of suit. It is not at all incumbent on the landlord to state the grounds of ejectment in the notice. It is for the court to judge whether the grounds for which ejectment has been sought for are available or not to the landlord on the date of the notice. If not, the suit fails, notwithstanding post-notice accrual of those grounds. To this function, so my lord, if the notice is issued, if the ground is not there, suit fails. And my lord,
which you were stressing upon till now.
Yes. And my lord, kindly straightway, my lord, come to 643. Here, my lord, the 92 CLT has been dealt with. It is not a good law. Page 643, have you lost it?
643.
Yes, my lord. Head note 465 at the bottom.
Notice of ejectment by a transferring landlord.
Notice of ejectment by a transferring landlord, it can be served prior to expiry of 1 year of transfer. The bar of subsection 2 of section 6 of the Act is only against filing of suit for ejectment on the ground of reasonable requirement prior to expiry of 1 year from the date of purchase of the premises. The said embargo cannot be extended to mean that ejectment notice cannot be issued prior to expiry of 1 year. Bindeshwar Prasad Gupta versus M.A. Mandari, 92 CLT High Court, Calcutta High Court, page 43, Division Bench. It is submitted that the law has not been correctly laid down in this decision. The ground or grounds of ejectment must exist on the date of notice. It is submitted by whom?
Achha. Dealt with this decision, which has been cited by the
By them.
appellant.
So, my lord, it is submitted that the law has not been correctly laid down in this decision. The ground or grounds of ejectment must exist on the date of the notice. Otherwise, the suit fails. No ground for ejectment under clause C or D could exist within 1 year from the date of acquisition of landlord's interest by the transferee. Here in the instant case, my lord, it also, my lord, same fact. The embargo or not against the notice makes the notice bad in the eye of law, as the landlord on the date of the notice had no right to claim ejectment on the ground of reasonable requirement. So my humble submission, my lord, this division bench, my lord, on the literal meaning comes to the conclusion, my lord, that, my lord, the literal meaning says, my lord, I have a copy, my lord, I am handing over to your lordship. My lord, can you keep it a Xerox copy, my lord? I have got this. So my humble submission before your lordship is that, my lord, since, my lord, this division bench does not lay down a good law, and, my lord, this division bench, my lord, has not, my lord, considered the judgment of the earlier division bench. Without considering the decision of the earlier bench, my lord, this judgment has been passed, and it has been, my lord, made on just literal meaning. Has no discussion so far as the notice is concerned. Literal meaning: suit filed after expiry of 1 year, suit is good. Notice issued, there is no embargo of issuance of notice. Notice good. No, has not said notice is good. Has not said so. Has said suit is maintainable.
I've got it, Lord Counsel. Next point. Next point is that commission.
Commission, my lord.
Reasonable
Well,
requirement.
this is a, my lord, in a suit for on the ground of reasonable requirement. My lord, I am placing, my lord, so far the reasonable requirement ground is concerned.
The
Both the
landlord has to prove his case.
landlord, my lord, burden of proof. Burden of proof lies upon the, my lord, the plaintiff, my lord, to prove his case. In the instant case, my lord, the landlord trial court held, my lord, reasonable requirement, my lord, against me. I preferred appeal before the landlord court of appeal below. Landlord court of appeal below, my lord, held, though, my lord, says, held, my lord, the ground of reasonable requirement against me, there is a ground in my humble submission, my lord, without preferring a cross appeal before this honorable court. My lord, I can, my lord, urge, I can agitate the ground of reasonable requirement, as has been, my lord, discussed by the London Lower Appellate Court. without in my on the first day, my lord, this point was my lord urged by by my learned senior judge. But without finding the head, my lord, the lower appellate court also, my lord, held my lord the reasonable requirement against me. Just I am placing the principle of law. My lord, that is reported in my lord AIR 99 Supreme Court 3571. Paragraph 22. 3571. I'm placing my lord. I have a copy, but I just I am not getting.
Once again,
I'm placing my lord.
refer to the
In-
citation.
Malad?
Refer the citation. Refer.
Yes. 99 Supreme Court 3571, paragraph 22,
99 Supreme Court
page 3571,
3571.
paragraph 22.
Yes.
In our view, the opinion expressed by Mukherjee J of Calcutta High Court on behalf of the division bench in Nishambu Janas case 1985 CWN, the view expressed by UN Bachwat J in Tejkumar case in 1981 Madhya Pradesh in Madhya Pradesh High Court reflect the current legal position after the 1976 amendment. We hold that the respondent dependent in an appeal can, without filing cross objection, attack an adverse finding upon which the decrease part has been passed against the respondent
Without finding cross objection.
without filing cross objection or cross appeal. For the purpose of sustaining the decree to the extent that the lower court had dismissed the suit against the defendant, respondent, the filing of cross objection after 1976 Act is purely optional and not mandatory. So, so far as I have handing over the judgment copy of the judgment. Paragraph 22 it says so. I'm placing the judgment of the landed lower appellate court. What the landed trial court did, landed trial court says, my lord, come to the conclusion so far as the ownership point is concerned, my lord, only on the basing on the 7-2. I have, my lord, indicate the judgment of this honorable court, my lord, that finding is a tentative. That is only for the purpose of disposal of the 7-2, not for the final disposal of the suit. If the case is otherwise, if the, my lord, suppose, my lord, the point of ownership is decided along framing issue along with the 7-2. In that event, that is final. But that has not been done in the instant case. Here, my lord, only 7-2 has been disposed of. So my two findings, so far as the, my lord, the ownership is concerned, and my lord, the reasonable requirement is concerned, my lord. But the appeal court goes against me, my lord, so far the reasonable requirement is concerned, my lord. But I'm placing the my lord, the findings of the reasonable requirement once more. Well, kindly place to my lord 38. Kindly come 38 of the paper book.
Correct counsel, 15 minutes. 1-5. Page 35.
Yes, 38. Here, my lord, I am coming to the point. My lord, dealt with so far as this is tentative finding, so far as the ownership is concerned. And my lord, page 45.
Yes.
Burden of proof is on the landlord to prove his ownership to the suit property, notwithstanding the provision of section 116 of the Evidence Act. So, in the case at our hand, the respondent was bound to prove before the court that she had purchased the suit property from the trustees on the said property, and that the sanction of permission of the learned district judge was obtained in regard to the such purchase, and that there was no defect in the said title. It appears from the cross-examination of the PW1, Avani Kumar Ghosh, that the respondent had in her possession the certified copy of order of the learned district judge passed in respect of the permission to sell the suit property, but for the reasons best known to the respondent, she did not file the said document before the court. In my opinion, the learned trial court erred in relying on the recitals of the title deed of the respondent number exhibit 1 to be satisfied about the existence of permission of the learned district judge, South 24 Parganas, regarding sale of the suit property without perusing the actual order in question. The mere mention of the recitals in the title deed of the respondent about the existence of the order of the learned district judge in regard to the sale of the suit property would not suffice, and cannot substitute of the need to produce the actual order in question to discharge the burden of proof that lay on the respondent to show that she had a valid title of to the suit property. Accordingly, I cannot agree with the observation of the learned trial court in this regard, and hold the same to be erroneous and not sustainable in the eye of law. The respondent has failed to show that she has a valid title over the suit property. However, it is to be observed that I also cannot agree with the view of the learned counsel for the appellants that the learned trial could decide the issue regarding right title interest of the respondent in the suit solely on the basis of the observation made by the state court while disposing of the application under section 7.2 of the West Bengal Premises Case Act 1997. It is a fact that there is observation made by the learned trial court that it was already been decided that the respondent is a landlord of the suit premises. As such, there is no further need to determine the matter, but the learned trial court also made its independent observation in dealing with the issue did not include the matter only on the basis of the earlier findings. So, my lord, the findings of the learned trial court, my lord, is not based on, my lord, on a trial, my lord, that after, my lord, scanning the evidence in trial, that has not come to the conclusion, only on the 7.2. So, my lord, till today, and the appellate court, my lord, did not, my lord, has differed from the decision taken by the learned trial judge. So, my lord, as on this date, my lord, the ownership right is still in question. Ownership right of the the landlord still in question. Since he did not produce the permission from the district judge. If the simple simple properties purchased, in that event this question would not come into play. Here, the question is something different. The property is something different. Devoto property. You have to show precondition of sale. Permission from the district judge is required, precondition of sale. But that has not been complied, and that is the reason why the lower appellate court also did not concur with the findings arrived by the learned trial court. And subsequently it deals with the notice. I have emphasized on this point. Kindly turn to this. I am assailing, though I am banking upon the judgment of the lower appellate court, so far as the ownership point is concerned, as well as the notice is concerned. But so far as the reasonable requirement ground is concerned, I am my lord, I am my lord assailing this because my lord, in view of the decision, my lord, without filing any cross objection, I can assail this. My lord, here, my lord, the learned lower appellate comes to the conclusion, page 49. Page 49, my lord, in the middle. Now the instant suit was instituted by the respondent for the eviction of the appellant from the suit on the ground of default and reasonable requirement. The appellant got the protection from eviction on the ground of default in terms of section 7 of the Western Constitution 1997, and the learned trial court decreed the suit in favor of the respondent, holding that the respondent and the family member reasonably requires the suit for their personal use and occupation. But section 6.2 of the Western Constitution clearly forbids the institution of any suit for ejectment on the ground of reasonable requirement by a landlord who has acquired title to the suit property by way of transfer within 1 year from the date of acquisition of title. In the case at hand, the respondent had acquired the alleged title to the suit property on 14 March 2005, and the instant suit has been instituted on 6th April 2006. So there is no doubt that the suit has been instituted after the expiry of 1 year from the date of acquisition of title by the respondent in the suit property. But admittedly, notice under section 6.4 of the West Bengal Premises Change Act 1997, Exhibit 13 has been issued on behalf of the respondent on 25th November 2005, which means before the expiry of period of 1 year from the date of acquisition of title in the suit property by the respondent. So the question that appears before this court for determination in this appeal is whether in such a case where the suit has been instituted after 1 year from the date of acquisition of title by the transferring landlord, but the notice has been issued prior to the lapse of 1 year, the suit can be said to be maintainable in law or not. In the case of Amarnath Sanjeev reported in such and such, it has been held that a valid notice to quit upon the tenants as a condition precedent in a suit for eviction. Again, in the case of such and such, the Honorable High Court has held that even though the grounds ejectment need not be set out in the notice, yet the ground must be existing and available when the notice was issued, and if there is no ground for ejectment, if a notice is still issued, that would be ineffective, because it is not the intention of the legislature that the notice should be an empty barrel. In the present case, as already we observed, the suit was decreed on the ground of reasonable requirement of the respondent on the basis of the notice issued by the respondent on 25th November 2005, Exhibit 13. But as the respondent had acquired title in the suit property by virtue of the deed of conveyance dated 14 March 2005, as such, on the date of issuance of the said notice, she did not have the ground of reasonable requirement available to her on account of the embargo as mentioned in section 6.2 of those conventions. As such, in the present case, the notice dated such and such cannot be said to be legal, valid, and the same cannot be sufficient to terminate the tenancy in question. The learned trial court, while dealing with the issue relating to the legality, validity, sufficiency of the notice, Exhibit 13 only concentrated on the point regarding its proper service and did not give due consideration to the question respect to the legality, validity, and sufficiency of the sufficiency to terminate the tenancy in question. It is observed by the trial court that no evidence has been laid to deny the fact that the notice was not proper one. In my considered opinion, the learned trial court are in law in this regard, as the question regarding legality, validity, and sufficiency of the notice is not a question of fact, but a question of law, and no evidence was required to be laid to determine the said question. Further, it is also erroneous to hold that there has been no denial on the part of the appellant regarding the fact that the notice was not proper. In paragraph 17 of the written statement, the appellants have clearly asserted that the alleged notice to quit is legal, inoperative, bad in law, and insufficient to determine the tenancy of the appellants. And the trial court itself framed the issue regarding legality, validity, and sufficiency of the notice to quit. The decision of the such and such, thereafter, my lord, in the middle portion,
Relied upon, you have already relied upon.
but the trial court, my lord, has not discussed so far as the validity of the notice. Trial court says notice issued, good, bad, well, suit is maintained. And so far, my lord, the result thereafter, the next part, the reasonable requirement, my lord, it goes, my lord, against me. But so far as the appellate court is concerned, my lord, so far that part is concerned, my lord, burden of proof. Landlord is required to prove, my lord, because the two suit property is in the same vicinity. Suit was filed sometimes in 2006. Now we are in 2007. My lord, there is a, my lord, threat of eviction of the landlord. Till today, my lord, he has not been evicted from his tenanted portion. So he is still in occupation in the same locality. That has not come to the court. And, my lord, so far as the requirement available to the landlord, that is required to be brought to the court on the ground of reasonable requirement. And, my lord, court is required to, my lord, analyze how many family members is there, how many rooms are in occupation of the property in question. That is also required to be gone into. My lord, humble submission before your lordship, my lord, on the very first point, my lord, if the suit is bad, if the notice is bad, should not maintainable, then everything my lord is useless.
Anything more? Nothing more. You have exhaustively submitted. Learned counsel, on the next date or today itself, how much time will you take?
Yes, my lord, lot
As
of
regards to
things.
notice, no lot of things. As regards to whether the notice is valid or not.
No, not only notice, the genuineness of the genuine requirement of the local inspection. That is also a point of law. And the service. Service is a question of fact that cannot be gone into. And also presumption as to the recital kept in the registered document. As to the existence of the permission. of
Permission by the district judge.
district judge.
First point.
That's the
Second point, notice
notice and whether the
and commission.
Local
39 rules.
rule 7, whether that is a sine qua non or not, as claimed by the learned senior. Next,
On the next day,
we shall also file written notes of argument.
written notes of argument.
Need fortnight at least.
No.
Then
Not
7 days
fortnight.
at least. 7.
When this bench will be available.
Yes.
Apart from this one judgment which my learned has cited, so far as the 92 CLT is concerned, there is no other judgment. That judgment on is passed on literal meaning. There is no embargo, statute does not say so, so it is. But this is not banked on, not on analysis, on point of law.
That will be real.
You have relied upon only one.
Yes, yes, on the point of notice.
One CLT 48.
Yes.
Well, apart from
Next day I will be dealing with many others.
apart from
Many others.
আবার কি করে হয়?
In reply to
In reply
to the judgment shown by him.
only law point.
Yes, on the point of law. Strictly on the point of.
Apart from on this judgment.
No, not on that point. Other points he agitated.
Apart from this judgment, I have handed over to all the Xerox copy. I will next time I will hand over to the lordship. So far, the better point of law, we have to accept this.
It's the Learned Counsel representing the respondents commences the submission. Further commences the submission and concludes the same. Full stop. Paragraph. The Learned Counsel representing the appellant seeks an opportunity to give reply. He further submits that for the next day. So both of you be kind enough to furnish written notes of argument.
Mala.
Let us submit that written notes of argument will be provided. As there is another bench